I have a lordship kindly to mention one matter.
Yes.
My Lord, here, my lord, I would like to prefer a second appeal against the order of the ADJ Shialla. My lord, here, what has happened, my lord? The learned court below has passed an order evicting me from the premises, my lord. Now the order has been passed on 11th of February 2025. My lord, I have to prefer an appeal within a period of 90 days. In the meantime, what has happened? They have put this decree on execution, and 3rd May is fixed for taking possession by the bailiff. So, my lord, in the
What are you wanting now?
my lord, I want to pray before lordship. My lord, second, two limbs of submission of
Yes,
prayer, my lord.
what?
First is that, my lord, in the meantime, I have procured the appellate court order, but my lord, I could not procure the judgment of the trial court. So, my lord, I would
File it,
prefer-
it will be defective. File it in the department.
the second limb of submission is the my lord, on 3rd is fixed for taking possession of the.
What can be done? You have to file it first.
My lord, I am filing. My lord, if your lordship kindly takes it up on tomorrow, my lord.
No, no.
My lord, unless your lordship kindly sees this is the
The
order
question of
passed by
taking up
the-
tomorrow. Tomorrow we take up single matters. You
Lord,
should
if
have
your
filed
lordship
earlier.
kindly peruse this order, my lord.
No,
I have annexed
we
this
won't.
order.
Sorry, no.
My lord, unless my lord,
No.
they will take possession,
No.
my appeal would become
You should have
infatuous.
mentioned earlier then.
Lord, I have procured
Sorry,
the order.
yes.
Lord, if your lordship kindly.
And for inclusion to be mentioned, my lord.
Yes.
There was the direction for my lord to deposit the
Not done.
postal. I have deposited beyond time.
Where will you accept? To mention, yes.
My lord, for inclusion of a hearing matter.
No hearing, no. Yes.
My lord, for release matter.
Yes.
My lord, for inclusion of hearing.
Hearing, no. Call on this.
Lord, kindly consider, my lord.
No.
Lord, I will.
Mr.
Lord.
Mondal, you
Lord.
have to know when to stop. Yes.
Lord, I will.
Kindly, with your kind
Taking
leave, I'd like to mention one matter for application.
Lord, I am praying for inclusion of the order 47.
Yes. Order 47.
Lord, may I?
Order 41.
Lord, may I please for one thing, Lord?
Yes, call on
Lord,
this.
may I mention it tomorrow after filing this
No.
with the leave of your lordship, Lord? Lord, unless my lord, your lordship
Tomorrow you
kindly.
cannot mention, sir, we are taking up single bench tomorrow. You know that very well. Yes, call on the list, please.
Lordship, what was order 41 rule 11? Or is heard by your lordship?
Not today. Come back on Monday. Yes, call on the list.
I appear on behalf of the respondent number 1.
Yes.
The plaintiff, lordship.
Respondent number 18.
FMAT number 42 of 2025 is dismissed on contest, thereby affirming the impugned order dated. The details are given. Can such and such is accordingly dismissed as well. No order is to cost. It is made clear that the merits of the issues involved in the suit have not been entered into by this court, and the above findings are tentative in nature, confined to the adjudication of the appeal against the temporary order of injunction, and shall not be binding on the learned trial judge at the stage of final hearing of the suit. It will be open to the learned trial judge to decide the suit on its own merits without being unduly influenced by the tentative observations made above. Urgent certificate.
Obliged.
Deeply obliged.
Same. Dismiss FMA 263 of 2025 is dismissed on contest, affirming impugned order. Consequentially, can 1 of 2025 is also dismissed. No order is to cost. Made clear that the merits of the issues not gone into, trial judge can proceed to decide the suit independently without being influenced. Whatever you have. Yes. Get a name. Party. Yes.
The bank of the husband is the Allahabad Bank, my lord. Jodhpur branch. Economy is there, my lord. Taking instruction.
But I am giving the intimation letter, my lord, from accountant bank. Allahabad Bank is the husband account and Punjab National Bank is the wife's account.
Allahabad Bank Chourangi branch.
No, my lord.
Jodhpur.
Jodhpur part. Now,
So same order remains, we will just make it Jodhpur branch. We are just reading the ordering portion. Rather taking into consideration the changed circumstances, we pass a fresh direction on the, that has to be that Allahabad Bank Jodhpur branch, where the pension account of the respondent husband in terms of PPO such and such is lying to pay the amount of maintenance at the rate of rupees 2,500 per month to the appellant wife directly to her account maintained with the Punjab National Bank. Sorry, again this will also.
Malad. And Malad, regarding arrear alimony, Malad,
Yes, arrear. Yes, what is the arrear?
3,60,000 till April 2025, Malad.
3 lakh.
60,000. 360. And till April 2025.
So we'll direct the bank also to deduct what is the total pension. You
Malad,
cannot deduct the entire pension.
Malad, pension amount, Malad, I have a letter in the year 2020.
Just tell us.
12,110 per month, effect from 2014, my lord. This is letter of 25th August 2022.
So we'll direct that.
At the time of my lord,
arrears also will direct. Arrears also will direct to be deducted along with the current account amount, 2,500 current and.
He is physiotherapist, my lord.
কি থাকবে
Taken VRS. Now it is increased, my lord.
নতুন অর্ডার করতে হবে তাহলে অ্যাপ্লাই করতে হবে এই অর্ডার করা যাবে এটা জাস্ট মডিফিকেশন যে অ্যাকাউন্টের জন্য
10,000.
যেটা আগের দিন অর্ডার আছে না সেটাতে একটা অ্যাড করে নাও একটা প্যারাগ্রাফ অ্যাড করে নাও আচ্ছা স্টার্ট দিয়ে দিয়েছি যেখানে যেখানে পাঞ্জাব ন্যাশনাল ঠাকুরই আছে সেখানে সেখানে ওই এলাহাবাদ ব্যাংক ওটা প্রথম কথায় লিখে দিয়েছি এলাহাবাদ ব্যাংক যোধপুর আর একটা প্যারাগ্রাফ অ্যাড হয়ে যাবে লাস্টে apart from the said current amount of alimony, comma, it is submitted by learned counsel for the petitioner wife that the arrears, comma, due to non-payment of alimony, comma, has accumulated to a quantum of rupees 3,60,000 till April, comma, 2025. Full stop. Hence, comma, we further direct the Allahabad Bank Jodhpur branch to deduct rupees 2,500 per month over and above the current alimony of the same amount, comma, making the total to be rupees 5,000 per month for the purpose of deduction from the pension account of the respondent husband and crediting the same to the account of the appellant wife, comma, the particulars of which have been given above. So we add 2,500 per month.
Man, 5,000. It would be
5,000.
Man,
He will have only 7,000 in his hand. In his.
No, my lord. He is
but he-
physiotherapist and it is increased, my lord. 2022, 10,000, my lord. It is increased now, my lord.
The
And
documents filed today will be
physiotherapist,
kept.
he is not record pension, my lord.
Till
Part-time,
realization of the area, till realization of the area.
I'll line
Man, it may be
till realization of the
I-
arrears of rupees 3,60,000.
5,000. It may be
3,60,000. Last digit arrears.
5,000, my lord.
That will take away his entire pension.
It will take too much time, my lord. To adjust, to realize.
For maintenance.
Yes.
5,000 মাসের ডিডাকশন থাকে না 5,000 করে পাক হবে তাহলে কি করি বলছো একটু বাড়িয়ে দেবো একটু বাড়িয়ে দিলে ওর কিছু থাকবে না কাছে ভালো Yes, sorry.
There is an interim order of 29th October 2024, which was lastly extended on 20th February 2025 till today.
But I need one more extension, my lord.
Well,
Just for 7 days.
Well, a time to extension cannot be granted possibly because the order records last order, no further extension shall be granted.
My lord, that is, my lord,
Two
subject to
extensions have been
subject.
granted.
My lord, only one extension I am seeking. My
Well,
lord,
the
they are enjoying
time
an
has
interim order.
expired
They
on
are enjoying an interim order. So,
March
my lord,
25.
only 7 days I am seeking, my lord. Next month, next, আজকে কত?
You're seeking an extension for what, Mr.
My
Mojumdar?
lord, for
Affidavit in opposition.
opposition, my lord, opposition to the stay.
Opportunity is recorded in the earlier, no further extension.
My lord, kindly give me just 7 days time.
You cannot modify that order.
My lord, kindly give me 7 days time.
No, no. Specific direction. There were previous occasions also you had
Yes, my lord.
must have asked.
Two extensions had been granted.
Total 3, including the last
Yes,
3.
my lord. Last one is the third extension.
No, sir. Cannot. This pertains to what? What sort of a matter?
My lord, there was a direction for a CBI inquiry that had been stayed. There was a police inaction writ.
Unless you
From
get their opposition,
My lord,
cannot
this
adjudicate
matter,
properly.
this matter probably has to.
you'll have
My
to
lord,
pay
there are
cost
two-
then. You are for? You are for
petitioner,
what?
writ
My
petitioner
lord, we are
responded.
for the writ petitioner.
Or you are seeking extension for the reply?
Opposition to the, my lord,
I am
this
the
stay
I'm a
application.
respondent, my lord. In the writ
Stay
petition,
application, they have filed. My lord, I am seeking opposition to the stay application.
Same what? Same as Mr. Mujumdar?
Here also some of the respondents in the connected appeal.
I leave it to your lordship.
1 week.
1 week time I am seeking. My lord.
I am also for one of the appellants. Deluge of affidavits will not change the adjudication. Whatever was, affidavits
But
were
there was a
before the
deluge,
learned judge.
there was a deluge of police personnel, my lord, when they entered into my factory premises and took possession of my factory.
No, that has to be
No,
decided by your
My lord,
lordship, my lord.
yes, my no, that has not been
Several
stayed.
opportunities, Mr.
No, only 7 days, my lord. My lord, my lord,
Each of
kind-
you, how many of you, let us, which respondents?
my lord, kindly put us to cost, my lord.
You are
whatever.
which respondent?
My lord, we are respondent number 1. Stay.
Who else wants to file?
My lord, respondent number?
Workers union, you don't know. What is the respondent number? Yes, respondent.
Well,
All of you want to. Respondent 15. Why didn't you prepare? All of you prepare.
আমরা তো respondent number 1. ঠিকই তো বলছি। হ্যাঁ, এই তো respondent
You don't believe in almost. This was the last chance given to the last opportunity was the last chance.
Yes.
Let us see. I mean,
No further extension.
on 20th of February, it was given till 30th of 1 month was given to you. Why did you fail to do
7
it?
days I am seeking. It is more or
No,
less
7 days. No, the third. This is the third occasion.
My
Why
lord,
should you
7
extend it?
days, my lord, only 7 days. Kindly, my lord, impose cost, whatever your lordship, put us to terms, my lord.
One thing should be brought to the knowledge of this court.
Yes, let's-
Item number 5.
First, let us finish with this. Respondent number 1 wants to file affidavit in opposition. Who else?
My lord, respondent number 9 also. My lord, respondent number 9 also.
That is
Respondent-
matter. You are enjoying an interim order.
Yes.
May I, my lord,
My lord, the
just
appellants
say
are
this?
enjoying interim order.
There is also, I must put this to your lordship's notice. That Agurpara Company Limited, there are two rival factions who say that I am authorized to represent the company. One is me, my learned friend. This is again, in any appeal which is filed by the other side, he's been served. And I have also filed an independent appeal. So that is also a controversy which your lordship will.
We'll have to decide. But for the time being, your respondent number? Give the numbers.
He's not a respondent according to me.
He has been added as a respondent.
Yes, so I am
not
going to
authorized, he's
represent
not
that
authorized.
respondent because the board of directors
Even then,
authorized me to
he
appear.
has a right to file a. He's a party to the application.
No, I have filed Vakalatnama.
He's a disputed respondent. my lord.
This is the
Maybe.
situation.
Everybody has a right of hearing.
Yes, yes.
You can't give your respondent numbers, so we won't grant you time. 15. 1 and 15 were 14. Who else? So these 3 respondents you are extending the time, rest no.
My lord, 13, my lord. I'm having some difficulty to switch
No,
on my
all of
video
you
net.
have not filed, then we will not extend. Sorry, no. No.
My lord, only us, my lord, only.
Several sets of respondents seek extension of time to file affidavit in opposition. Push-up. It is rightly pointed out on behalf of the appellants that by the order dated February 20, 2025, a coordinate bench had recorded that no further extension shall be given. Push-up. We also find from the records that February 20, 2025 was the third occasion when such extensions were sought by the different sets of respondents to file their affidavits in opposition. Push-up. Next para. Since ample opportunity has been given to the respondents to file their oppositions, lastly being for a period of about a month, we find that there is no conceivable reason as to why we should further extend such time. Full stop. Accordingly, the prayer for extension to file affidavit in opposition made by the different sets of respondents is refused. Full stop. The matter shall proceed without such affidavits in
I'm
opposition.
the read petitioner, my lord. I'm the read petitioner.
Maybe.
The interim order expires.
Respondents took read petitioner করে দিন।
Well, the
Interim
interim order
order
has
expires.
to be extended. Interim order is still
Well, let it be heard
Till
before
today.
vacation.
The interim order granted earlier stands extended till June 30, 2025 or until further order, whichever is earlier. Full stop. The matter be listed for hearing in the monthly list of June 2025.
Obliged.
Your Lordship, in item number 5, Your Lordship, it's my appeal, Your Lordship. There was a CAN application filed. My opposition is ready. May I just file it, Your Lordship?
You are within time.
Yes, I'm within time, Your Lordship. It was affirmed and I will serve a copy.
You are for the respondent in 5.
Yes. No, I am for the appellant in 5.
This is an opposition.
Your Lordship, they filed a CAN
This
challenge.
is an opposition you are trying.
Yes.
The affidavit in opposition filed by the respondent,
CAN 2.
filed by the appellant in 5.
Filed by the respondent in the appeal.
Respondent, you are Agarpara.
I am the state.
Filed by the appellant in MAT 2022 of 2024. Today be kept on record.
Item number 5, I have prepared the affidavit of which we have served. The appellant has not filed a reply. State has not filed a reply.
So what are you doing so long? So long you are asking for extension.
In the item number 5, in the item number 4, I was seeking an extension.
Acha. You are for the respondent. The affidavit in opposition filed by the respondent number 8 in MAT 2022 of 2024 be also kept on
Your
record.
Lordship, grant me 7 days to file a reply to this.
Well, may I just
The time for filing reply to the said respective affidavits in opposition is
so
extended
far as the appeal,
for a fortnight from
well,
date.
one prayer, my lord. So far as the appeal preferred by the state, well, can I get the opportunity to file affidavit in that appeal?
No further opportunities, whatever.
Well, the state is not opposing that.
We'll proceed on the basis of the papers which are there. No. Next.
Grateful, ma'am. Grateful.
7, yes.
6 Miller, there was a interim order with item number 4. I'm the appellant in item 6. So interim order, Miller, extending.
No, interim orders which granted earlier. Interim orders we have said. Interim orders করে দাও ওটা।
In all three matters.
Yes.
All the matters.
Interim orders granted in all the matters be extended till যা বললাম।
Grateful.
Yes, Charu Diesels, Mr. Chaudhary were there.
Yes, I have not prepared the note.
Both the appeals.
In both the appeals.
Yes.
Miller, may I ask for Miller the indulgence, Miller? Few changes I was reading it in court.
We'll keep it on Monday then.
No, not Monday, Miller. I'll give it in half an hour, Miller.
Yes,
to my
please,
lord's office.
permit you. Yes. You?
We have prepared a composite note as pursuant to my law's direction.
Whatever.
Miller,
Yeah, hand over
by
the notes.
11:30 I will give it. I just want to check it once.
On the prayer of learned senior counsel for the appellants, leave is granted to the appellants to file their affidavit, their written notes of arguments during the course of the day. Full stop. The composite written notes of arguments filed on behalf of the plaintiffs to respondent number 1 be kept on record. Full stop. Hearing is concluded in the matter and the matter is reserved for judgment.
Grateful.
Do it, Mr. Chaudhary. Ensure that it's done.
The compilation referred, my lord, is the compilation filed by the respondent. There's a reference to compilation by in my note. We have filed a compilation. It's a voluminous document.
Already.
That is a document.
সব কাগজ শুধু করে।
I'm so great.
এটা উনি ফাইল করলে ওটা দিয়ে তারপর
আমি ওর পেজ নাম্বারই দিয়েছি।
Great.
So you refer to the same compilation.
Yes. I've used the page numbers because
Thank you
I
very
thought
much.
it would be easy.
Thank you very much.
Great.
Next. Yes.
For the respondent, my lord, some difficulty, my lord. I'm for the appellant.
They are finished.
No, my lord.
It was adjourned on your prayer on the last provision.
My lord, what happened, my lord? There were another set of paper book, my lord. I have been served with part 1 and part 2, and
It is hard in part, Mr. Bhattacharya. You cannot grant adjournments after
What
adjournments. no.
what happened, Milord? Milord, I usually I do not pray for adjournments. Milord, what happened, Milord? Either they have not given or my clerk had misplaced. Milord, I could not prepare myself.
Mr. Bhattacharya, you should have indicated earlier to them. no.
I'll come back, Milord.
No further time. It's a hard in part matter. Then we'll
I'll
cancel the part hard. You are enjoying an interim order. Sir, are you enjoying an interim order here? Must be. This is against what?
Yes, they were giving opposition charges.
Interim order is there.
I'll
We are
come back
paying-
next
No,
Thursday.
Mr.
10,000
Bhattacharya.
per
Then we'll cancel the part hard. It will appear in the due course. No adjournments in part hard matters. Sorry. Learned counsel appearing for the respondent seeks
me
an
one chance,
adjournment.
Milord.
No. Seeks an adjournment in the matter. Full stop. We find that the matter is heard in part, was heard in part. Full stop. On April 24, 2025, comma, we recorded that the matter was heard in part and kept the matter for further hearing on April 28, 2025. Full stop. On April 29, 2025, comma, when the matter was next taken up for hearing, comma, an adjournment was sought on behalf of the respondent. Full stop. Even today, comma, at the time of call, comma, the respondents seek an adjournment. Full stop. Next para. We find that in view of the repeated adjournments being sought by the respondents, comma, the matter should not be retained in our list as a part heard matter. Full stop. Accordingly, the part heard within double inverted part heard marking in the matter be cancelled. Full stop. The matter be placed in the list under the heading hearing in regular course.
Lordship would kind
এটা
enough
দিয়ে
to-
দেবেন সোমবারই দিয়ে দেবেন কিন্তু হিয়ারিং লিস্টে
Lordship would kind enough to only
পার্ট
record
হারটা
that.
ক্যান্সেল হয়ে গেছে আর পার্ট হার হবে না
Lordship would kind enough to record that, Milord, in view of page 119 of the paper book, Milord. Milord, the paper books which have been prepared is incomplete and I am unable to prepare myself
Whatever.
because these
You
documents
should
are
have pointed out, you knew this on the last occasion itself. You should have done it on the last occasion.
Milord, these
We won't
documents
keep
are,
part heard matters pending, no. Sorry.
these are, Milord, in
No, we can't include matters in the list, Mr.
I
Bhattacharya.
understand.
No lenience regarding part heard matters in appeals. Next.
The referring claimant appellant in the second appeal and state is the appellant in the other.
The two appeals were filed, Milord, one by the referring claimant and one by the Milord, the
Yes. What is the matter?
land acquisition case, Milord.
Yes, so one of the please argue. Argue, please.
Milord,
Make the arguments.
Milord, may complete the judgment, Milord, it was read, Milord, Milord, some portion, Milord. was
Whatever way you want.
complete, Milord.
Very good. Which page?
It starts from, Milord, page 54.
What are your points in the appeal? Please clarify that first.
Milord,
Then we'll know what to look for in the judgment.
Milord. Milord, my point is this, Milord.
You are for the state.
Milord, for the state, I'm the appellant, Milord.
Very good.
Two appeals filed, Milord. One by the referring claimant,
So you are for the state
Milord.
and the land acquisition collector in the other.
Milord.
Very good. Yes. What are your points in the appeal?
Milord, although it's a reference case, Milord, the land accord is under Act 1 of 1894. Section 5(1), Milord, notice was issued. Some petitioners, Milord, moved a writ petition before this honorable court, and pursuant to this honorable court, Milord, that was set aside, and again, Milord, it was, Milord, revived.
Under the same act, another
Same
notice?
act, same act.
Again, a notice
And
was
as
issued.
this honorable court, Milord, directed to proceed with the matter, but the reference case, my lord, under section 18. But the determination of the compensation will be, my lord, as per provision of the new act, my lord, Act 13.
What is that judgment?
My lord, it starts from, my lord. Well, your lordship, kindly turn to page 57 of the judgment.
All right. All right, we have found it. Yes. 2013.
Milord. Milord, bold letter, Milord.
Bold letter is there.
It is to be noted that the Honorable Court had been pleased to direct the Land Acquisition Collector Hooghly on 25th July 2016 to the effect that the reference petition shall be heard and adjudicated by the court as referred under section 18 of the Act 1 1894
with a reasonable time as per provision made under the right to fair compensation and such, my lord. As because Section 26 of the Act 2013 has laid down a particular procedure to determine the market value of the land being acquired in pursuant of notification being issued under Section 11, and since no notification was issued under Section 11 of the since, and since the notification was already done under Section 4 of the Land Acquisition Act 1894, that is on 20th September 20, that is the date of notification.
Yes.
Miller, that is the date of notification.
So after this is that fresh
My lord.
exercise. So what is your point now? What is the error in the court's judgment?
My lord, the referring claimant, my lord, submitted 5 deeds before the honorable court. Learned court below, my lord. Out of which, my lord, 2 deeds are, my lord, after the date of notification.
All right.
That should not be, my lord, taken into consideration.
All right.
Other deeds, my lord, as per Section 26, my lord,
Right to fair compensation একটা আনিছেন
my lord কে খুলে দাও না my lord কে খুলে দাও এইটা দিয়ে দাও এটা এটা my lord কে দিন
ওটাও লাগবে আর ল্যান্ড অ্যাকুইজিশন একটা যেটা 1894 এর সেটাও লাগবে সেটা আছে আপনাদের কাছে
এটা এটা my lord কে দিন দুটোই দিন
রাইট টু ফেয়ার কম্পেনসেশন
my lord
we have
Section 26 এটি 1894 একটা আছে
1894 একটা বড় দিন ল্যান্ড অ্যাকুইজিশন just check the land.
May I read? Section 26. Determination of market value of land by collector. The collector shall adopt the following criteria in assessing and determining the market value of land, namely the market value, if any, specified in the Indian Stamp Act 1999, or for the registration of sale deeds or agreements to sell, as the case may be, in the area where the land is situated, or the average sale price for similar type of land situated in the nearest village or nearest vicinity area. Concentrate amount of compensation as agreed upon under subsection 2 of section 2 in case of acquisition of land for private companies or private or public-private partnership projects, whichever is higher, provided that the determination of market value shall be the date on which the notification has been issued under section 11. Explanation 1. The average sale price referred in clause B shall be determined taking into account the sale deeds for the agreements to sell registered for similar type of area in the near village or near vicinity area during immediately preceding 3 years of the year in which the such acquisition of land is proposed.
Yes.
To be made. Well, Lord, here the notification, my lord, 20th September 2011. Therefore, my lord, the preceding 3 years, my lord, prior to the date of my lord, the notification, the referring claimant, my lord, submitted 5 deeds, out of which, my lord, 2 are after the date of notification.
So those go. What about the other 3?
Other, my lord, is this, but the landed court, my lord, taken the market price, my lord, not the sale price. Sale price is, my lord, different, my lord. My first point is this, my lord, and second point is, my lord, is this. This was not exhibited, my lord, before the landed court below. And we have submitted, my lord, sale data. On the last occasion, my lord, I have referred before your lordship, sale data 15039, sale data. My lord, it appears from page 5 of the paper books.
Sale data was exhibited.
Sale data was not. It was submitted before the honorable court. It was not submitted.
Then on the same footing.
Same footing, my lord. Same footing, my lord. But the landed court, my lord, not taken into consideration the any sale data, whichever, my lord, was produced before the landed court below.
Sale data for last 3 years.
Last 3 years, my lord, it starts from, my lord, page 5. That is from the year 2008 to 2011, my lord. And my lord, all the lands which were, my lord, they have submitted the deeds before. That is far away from the point of location, my lord, and the nearest to the main road. 20. The prime, my lord, that is, my lord, the shoot plot, my lord, is a big metal road, prime location of the 20 feet wide. That is not from the local, the vicinity or the area concerned. And my lord, those deeds which are, my lord, submitted before the learned court, that is with the structure. That means the structure value, my lord, should be deducted. That should not be taken into consideration. But the learned court, my lord, have taken into consideration these rules, including the structure. And my lord,
আর কি বলবো my lord, দাঁড়াও কোথায় বলার ছিল আমাদের একটা
and we have, my lord,
একটা দেবে এটা ওই যে আমার জলসা যেটা নিয়েছিলাম তলা থেকে
we have, my lord, obtained a assessment slip after the notification, my lord, from the same sale plot which is, my lord, under acquisition.
Was that a part of the trial court records?
My lord, no.
Then we cannot look into it.
No,
Mr.
my lord.
Bandhu. We
But
cannot.
it appears from this, my lord, the valuation as on that, my lord, is much lower.
But we cannot look into that. New document, no.
And my lord Justice Kumar, Uday Kumar, my lord, sitting with my lord Justice Somen Sen, first another mention, my lord, the same, my lord, was the taken into consideration the value of the price, my lord, that as my lord lowered on. May I refer this, my lord?
Yes, yes,
With
sir.
my lord, I have submitted with my written of the submission.
No, no, my lord Justice Kumar might have considered that
Yes,
another
yeah,
matter.
my lord.
But here
Justice
we
Uday
cannot look
Kumar
into a
and
new
Justice
document.
Somen Sen, Justice Uday Kumar and
No, no, we are not disputing the validity of
we
the
are, my
judgment.
lord, submitting with this, the my lord written.
No, but we cannot look into new documents which are not there before the
My
trial
lord,
court in
yes,
this
my
matter,
lord.
Mr. Bandhopadhyay.
My lord.
That must have been there in the other matter.
My lord.
But here we cannot look into it.
My lord.
হ্যাঁ আর কিছু বলো না জোসেফ মেন পয়েন্ট জানতে চাইছেন বেশি কথা বলতে লাভ নেই my lord মেন পয়েন্ট হচ্ছে এইটা
So first is that they submitted 5 deeds. 2 of those deeds were after date of notification, so those should go. About the other 3 deeds, those are apart from not being exhibited, not of the vicinity, and with structure, value of which was not deducted. Your sale letter was in terms of the explanation 1 to section 26, last 3 years, but that was also not exhibited, but that was not considered, although that was in terms of the explanation. So these are your points.
My lord, the same vicinity and my lord, the sale price, which have been, my lord, taken into consideration by the learned court below.
Oh, that also.
That the
Market value was
market
taken,
value.
not
That
the
is not
sale
the
price.
actual sale price.
Not sale
That
price.
is, my lord, much lower, my lord.
That is
will
another
be much
case.
lower. And my lord, out of 5 deeds, my lord, 2 deeds will not be taken into account, my lord.
Yes.
3 deeds to be considered, my lord. But they have shown, my lord, the
We are repeating the points. One is out of those 5, 2 are after date of notification, so those should go.
My lord.
Second point, trial court took market price, not sale price.
My lord.
Third, 5 the deeds produced by them, the claimant, were not exhibited.
Yes,
Apart from not exhibited, not of the vicinity, and with structure, value of which was not deducted.
Yes, my lord.
Next point is that your sale data states sale data for last 3 years, which was in consonance with that explanation 1, that was not considered.
My lord.
And lastly, this assessment slip you are trying to rely on, but probably we won't look into it. But we'll record your submission that you are relying on it.
My lord.
Any judgment you want to cite?
Oh, my lord, really judge.
So that's all. We'll hear you and
My lord, any one more point, my lord.
just classically, because first appeals have to be heard over days, Mr. Bandhopadhyay, because you are the new generation. So
the main points.
these are the main points. So let
There
him
is
deal
no
with the
need,
main
my lord,
points.
to explain the such and such. So
Unnecessary.
unnecessary, my lord, that is not.
This would help the court so much.
My lord, another thing, my lord,
Yes.
we have filed an application under section 47, my lord.
41 rule 27.
47, my lord. Annexing the, my lord,
That was previously filed.
my lord. They have also filed, my lord.
They have also filed.
Both the parties, my lord, filed, my
What
lord.
do you want to produce now?
Register of market value monitoring, my lord. That should be, my lord, taken into consideration.
What is that? Register?
Register of market value monitoring, my lord, which is annexed with this, my lord.
But then you are also relying on the market value.
Market value. Market value, no, my lord. Sale price, actual sale price. Market value, my lord, we have, my lord, annexed with this.
Yes, but market value, you, according to your argument, we cannot
No,
look into.
no, my lord. Actual sale price. As per section provision, my lord, the section 26, my lord, I'm again reading my lord explanation. The average sale price, my lord, under section 11 shall be determined taking into account the sale deeds or the agreements to sell registered for similar type of area in the near village or near vicinity during immediately preceding 3 years. And another question, my lord, explanation.
But you are producing the register for
Register.
market value monitoring,
Value, my
which
lord.
goes against your argument.
No,
So
my
on
lord.
your argument, we are not allowing this. Market value cannot.
My lord, no, market value, my lord, I'm showing before your lordship for this, my lord. The market value is same another thing, my lord. And the actual sale
We
price.
can look into it. The trial court was justified and looking into the market value also.
No, my lord, market value you are not referring, my lord. The market value, my lord, that is as per assessment slip. And the sale price is, my lord, much below the, my lord, the market value which has been annexed.
Sale price we cannot get from your order for rule 27. So order for rule 27 goes as per your argument.
My lord. My lord, explanation for your lordship, kindly, my lord, please.
Acha.
Of the rule 26.
Yes, please.
While determining the market value under this section, the average sale price referred in explanation 1 or explanation 2 and price paid, which is in the opinion of the collector is not indicative of actual prevailing market value, may be discounted for the purpose of calculating the market value. Therefore, my lord, the LA collector, my lord, he has assessed the higher market value, whichever, my lord, the as per produce the sale data, my lord.
Mr. Bandyopadhyay, if market value was higher than the sale price, then section 26(1) permits the court to rely on the higher value. So you are saying in a blanket fashion, market value cannot be looked into. Why do you say that? If market value is higher, then market value can be looked into.
No, my lord. As per provision
26(1)(a) is that.
they have
26(1) is
annexed the, my lord, the deeds, which is what are taken into consideration.
no, not that. Your one point you made before us is that the trial court wrongly took the market value into consideration and not the sale price. Whereas the section says sale price. But section 26(1) is very specific. It has to be either the market value or average sale price or consented amount. Either or, whichever is higher. So if the market value was higher, then it could be looked into as per section 26.
Explanation 1, my lord, your lord, kindly see. The average sale.
Explanation 1 applies only if clause B is resorted to.
My lord, my lord, section 26B, average sale price, 26B.
Mr. Bandyopadhyay, section 26(1) says collector shall adopt the following criteria.
My lord.
And then 3 criteria are given.
My lord.
C does not apply because consented amount is no question.
My lord.
A is market value, B is average sale price.
Average sale price.
There is a disjunctive
Similar
or
type of land.
let us complete. Let us complete. A and B, don't mix up the 2 points. We are dealing with your point that market value could not be looked into, sale price should be looked into. But here 26(1) says either under A it can be market value or under B it can be sale price, whichever is higher. So if the trial court found that the market value is higher, section
does
says
not say that, my lord. A said, my lord, the market value if any specified in the Indian Stamp Act for the registration of sale deeds of agreement to sell, as the case may be in the area where the land is situated. B, my lord, the average sale price for similar.
B is not in bold letter. A and B, only you can stress on B, but A and B are on equal.
My point, my lord, is sale price.
Why? Because that was higher. Sale price was higher or market value was higher?
Sale price, market value is higher.
Then whichever is higher is written in the section itself.
No, my lord.
No. Please show him. So, Banerjee.
That was going to be our argument.
It's Banerjee versus Bandyopadhyay now. So Banerjee
We
wins
are
on
using
this. Yes, but he is using something which is not there in your arguments.
Bandyopadhyay is market.
Bandyopadhyay is overlooking higher price.
My lord, thereafter, my lord, provided that the date of determination of market value shall under Section 7.
That is, there is no dispute on that.
My lord, now it is up to your lordship, my lord, for consideration.
So if that is
It
there,
my
then we can look into your order for 27. We can think whether we can take it into consideration also. Any no judgment here. Yes.
Section 26, your lordship has seen 3 modes.
A is market value in the area. In the area is also important. I'll show. We have
Yes,
we
definitely.
have relied on A. B is average sale price. C is agreed price. C goes. They have done B. We have tried to demonstrate that A is available to us, and we have relied on the deeds to say it is price at A.
But Mr. Banerjee, market value, this market value, if any specified in the Indian Stamp Act for the registration of sale deeds,
In the area.
that cannot depend on your sale deeds.
No. If the
You
deeds
produce sale deeds, you did not produce market value. You could have produced assessment from the registration
sale
office.
deeds will not contain the market value. Now, after 2008, will not the market value, which is maintained by the department, is reflected in the sale deed. In the sale deed, will not the market value is reflected.
Oh,
We have-
in your sale deeds, market value was separately written.
As per the Indian Stamp Act, because market
Let us see those one of the
deeds.
sale deeds.
Fine. Because we have to pay the stamp duty on the market value maintained by the registration department.
Right. You may have the different consideration.
Consideration may be different.
Yes, you are right.
Then the market value will come to the
Show us those deeds.
we have filed one notes of argument. Page 15 is the chart
Well,
of
in
the
the
deed.
paper it's not there.
109, page 109.
Thank you.
109.
If your lordship not comes to the first deed, my lord.
109 is the first deed. It starts from 109.
109, there is a load shedding.
No,
112, it's the power cut starts. 116, it's pitch dark. Pitch dark.
Kindly comes to the
And the power never returns.
Kindly
throughout
come
the
to page
sale.
142, my lord. Because that deed.
Page 142.
Yes, that is the other deed. Next deed, my lord. Because
whatever the
that
first
deed
deed, it's not there.
it is there, my lord. It's not clear. That is why I'll show from.
No, the first page is clear. 110 is clear.
My lord.
You can rely on 110.
My lord.
Sale deed value is given 18 lakh.
18 lakhs.
Where is the market value?
Market value, my lord. Kindly comes to page 140, my lord. This is page 122. 122.
Achha, we will look into only those documents for the time being, those other three, because two were after date of
On
notice.
that also I have my argument, my lord. These deeds were executed, my lord. Stamp duty paid before the date of notification. But the registration was done 2-3 days after. So if the execution is done, my lord, because the concept
We'll come to that. First, let us see the market value reflected from. Where is the market value? Certificate of market value, page 122. 45, 76, 250.
My lord. Just a second.
Majghanta.
Yes, market value. Not,
yes, in the middle of that, 45 lakh 76,250.
Yes, that is the market value.
Certified that the market value.
45 lakh 76,250. Type copy is at page 140.
Oh, type copy of this.
My lord, type copy of this page is at page 140. 45 lakh 76,250. So set forth value is 18 lakhs. But the market value is, my lord, 45 lakh 76,250. We have paid the stamp duty on this price. It is much higher than the deed value.
And this was the basis of
this was the market value in the area. Now, in the area, I have to satisfy. They have taken a point that the deeds are much away from this.
We will go one by one. Mr. Banerjee, because the way he has argued, please address if you can. Otherwise, if you are prepared, otherwise.
No, I'll.
So, the first point taken by Mr. Bandyopadhyay was that 2 are after the date of notification. So, regarding that, you say.
On that note, if your lordship takes up this bunch, it's very helpful for me. I have filed a written notes of argument with a chart of the 5 deeds. Page 15.
Pages are given, the pages
yes,
number.
Everything is.
Well, the last 2 deeds, Milord, it starts from page 180.
Give a copy to him also.
Please, copy the notes of argument.
We have given.
He didn't think it important before today.
We have given.
We don't have a.
We can not find it out.
You have already given to us also.
Yes. We have
Who
filed
such?
because hearing comments not in this matter previously also before the other bench. So we filed this.
We hope the same fit.
This has the judgments also that we are going to rely upon. Everything is there. A bunch of them.
Most of argument are guilty. May I submit our my written notes of argument?
Yes, we'll take those.
দেখেন আছে কিনা
এই তো
আর কোনো কাগজ নেই, আমরা ফাইল করেছি।
আলাদা ফাইল তো নেই, আলাদা ফাইলের
আর কোনো ফাইল নেই তো?
এই দুটো তো
Filed on behalf of the claimant. File করা ছিল তো আমাদের। Because we argued on this matter before the court.
We can ask the previous judges whether they have
No,
taken
no,
it home.
Must be there. It has to be there, but I'll find. There are other files also. I'll check. I'll argue
Files are
without-
there? No, অন্য ফাইল রয়েছে যেগুলো ওগুলো দেখুন অন্য কোথাও গুঁজে রাখা আছে কিনা।
হ্যাঁ, দেখে নিন একবার।
ওই তো রয়েছে কিছু। ওটা না সাদার মধ্যে, সাদা ফোল্ডার।
একটা কপি দিন।
ওটা কি অন্য
ওটা কি
notes of
আলাদা?
citation যেটা রয়েছে? ওটা গুলিয়ে যাবে সরিয়ে
ওটা
দিন।
নিন।
হ্যাঁ এক্ষুনি গুলিয়ে যাবে।
First point is regarding not the date of the 5 deeds.
You said those incriminating two, those were executed before the date of notification.
Yes, my lord.
Registered after.
Registered after. The third deed is serial number 4 here, my lord. It was not transaction completed on not.
Give us the page numbers where we'll find it.
Page number is not 189 and 191 are the relevant pages for the second first deed. Page 189 and 191. I'll show from the paper.
And what about the second deed?
The other is, my lord, here my lord, stamp duty was paid on 25th of August 2011. Stamp
The
duty
first
was
deed?
paid. No, the other one, the next one. The first one, my lord, 20th September, it was presented. Transaction completed. The other is 25th of August, both prior. The other deed is page number 209 of paper.
But the date of date of execution is important, or the date when you paid the fees?
My lord, may I say this, my lord? The price is agreed in a deed. Stamp duty is, my lord, market value is.
But if you rely on the market value,
Market value.
then the market value was determined subsequently after the date
No,
of.
cannot be. When I pay the stamp duty, that is on the basis of the determined market value only.
There was no revision of
No
that.
revision. They have not made out any case that there was a revision in the market value. Previously, my lord, the concept was that when acquisition notification is given, then the price in the locality increases. The agreed price also increases. Set for value increases. But so far as market value concept is concerned, there cannot be any revision because of the acquisition notification.
Not that sort of revision. I mean, when you presented, was there any further adjudication on that by the registrar? Registrar said no, there is deficit.
No.
If that is so, then
No, that is not the case here, my lord.
So
Page 209 for the other
209.
document.
Page
May I just-
189 and 209.
Yes, 189, 191 for the
So
first.
these were executed before date of notification, registered after.
Yes, my lord. Stamp duty paid presented. So, my lord, it was presented prior to, because stamp duty has to be paid on the, my lord, adjudication
Executed
market.
plus stamp duty paid before notification.
And not presented and registered subsequently. So there won't be any revision in the market price. I'll just show the pages, not for your lordship's consideration. Kindly,
Let us
my
see from the paper book itself.
lord, page 89.
189. No, sorry, 189 is.
Yes. But may I just give the chart? I have the chart of the 5 deeds. If 189 is the first deed, my lord. Kindly see, my lord, the date when the deed was executed.
20th
Second line,
September.
20th September.
2011.
The date of the notification. So on the same day it was, my lord, signed.
On the date of notification.
Yes. Not subsequent.
You were
And-
parties to it.
No. It's in the locality, in the area. We
Yes.
were not.
Because same date, that's why you were asking.
We're lucky that we got the same date. my lord.
Yes.
And 191 is, my lord, date of payment of consideration, 191. Kindly see, my lord, consideration paid on 1st August and 19th of September. Both before the date of notification. So consideration paid, and so the first deed will not go. The next is 209. There was indeed some deficit stamp duty which was paid on 25th of August. If your lordship takes up not 209, towards the bottom, not deficit stamp duty, there is a not column. 48,630 to be paid. It was paid on 25th of August 2011.
No, but it was ascertained on that date only.
Yes, so that is prior to August.
Ascertained prior.
Ascertained and not.
If ascertained prior, then we go by that.
So,
even if we paid it later.
So market value was ascertained not prior to that date. From this date also reflects. So both the deeds, the market value was ascertained by the registering authorities prior to the date of notification. So that these deeds may be registered afterwards, but the market value was fixed by the authorities prior to the date of notification. So the first point regarding the 5 deeds, I said these deeds can be taken into consideration.
Yes, very
Now
well.
the question of exhibition, whether they were exhibited or not.
Yes.
On that note, my junior has not taken inspection of the records and prepared a note. These deeds, there were several cases. In the other case, the certified copies were filed. In this case, Xerox copies were filed. On consent, they were exhibited. Kindly must take up this note.
So they were exhibited, not that they were not
No,
exhibited.
exhibited, my lord.
Mr. Bandyopadhyay
Order
said
number
they were
12.
not exhibited.
Order number 12. She has, I was check going. Order number 12, they were exhibited. They said subsequently that no, Xerox copy cannot be done. We shall challenge it, but they have never challenged that.
All right. And regarding vicinity and with structure,
Vicinity.
the two other
Vicinity, my lord. This is a case where no written objection was filed by them. In our pleading, we have said that we shall produce the deeds of the area to show the market value of the area. That was the pleading. That was the pleading, my lord.
No objection was filed by the state.
No objection. No objection. So whatever evidence they rely upon,
In its usual.
we shall rely on a judgment that
That
any
is
evidence,
not my only problem.
any evidence
cannot
my lord, in the absence of pleadings cannot be looked into. We shall be my lord, relying on that judgments, my lord, because they have
No.
In our affidavit in chief, my lord, we have also stated that.
No, not only that, Mr. Banerjee, the pleadings need not be there in their objection. Yes, objection must be there, but because those deeds are produced on the basis of your pleadings,
my lord.
not their pleadings.
So they have to cross-examine on that. That is also absent. I'll show that, my lord. Kindly
They
see,
did
my lord.
not adduce evidence.
No,
they
they
adduced
have
evidence.
adduced evidence.
Did not
So far as
cross-examine you.
my, so far as no cross-examine, but no suggestion put to my client that the deeds are not of that area. When I say that I'm producing deeds of the area, they have
But that will be evident from the deed itself.
deed itself. Yes, same Mouja. Same Mouja, my lord. I'll show the definition of Mouja from Panchayat Act, which says Mouja is the smallest unit of area as per the provisions of the statute. I'll show that. I'll
You
rely on
worked
that.
hard for this.
Now, my lord, pleading is at page 26, my lord, para 11 of the paper book, where I have stated, paper book, page 26.
Page 11.
Page 26, para 11 of the paper book. Not I am reading the relevant
Yes,
portion, my
stated.
lord. The market value specified, 1, 2, 3, fifth line. Market value specified in the Indian Stamp Act in the area in question is much higher than the valuation assessed by the LA collector. It is specifically stated that the market value of the land in the area as specified in the Indian Stamp Act for registration of sale is around 5 lakhs per kata. And the referring claimant shall produce supporting document to establish such contention before your honor. Then, however, unfortunately, land collector has assessed at the
So same Mouja.
So we have said in the area, in the evidence, my lord, we have said while tendering the document, page 38.
Yes.
We have said, page 30, para 11, that I have filed 5 certified copies of the sale deeds to assess the market value of the relevant area of the relevant period. So I have stated that relevant
No
area.
counter suggestion to that.
No counter suggestion. And the cross is, my lord, at page 42. They only say very short, one paragraph. I'm reading this paragraph. I'm reading. Cross. Not a fact that I received compensation in accordance with the provisions of new legislation. Not a fact that the sale deed which were filed by me are not in accordance with the provisions of new act. Nothing more. They say it's not in accordance with new act. Not a fact that the value mentioned in para 12 is not correct.
But in accordance with new act covers
that.
Very
So they have to give a suggestion that the deeds are not of that area because it's a question of fact that they are of some other area. No suggestion. Without pleading, without any suggestion, they cannot now set up a case that the deeds are not of that area. But even then, I have to satisfy your lordship because if your lordship has to assess, it has to be on the basis of.
But you say same Mouja.
Same Mouja. The definition of Mouja should be Panchayat Act. Section 213 of the West Bengal Panchayat Act defines Mouja. That's it.
Section 2, subsection 13.
13 of the West Bengal Panchayat Act.
What is it?
Says it the smallest unit of area is Mouja. So when we submit not the deeds of the same Mouja, they are not to be considered as the deeds of the area.
Yes.
Now I have to satisfy your lordship. They have taken another point that the deeds are
Structure.
not of similar structure and not similar. We file an RTI before the authorities because all the deeds say 100 square feet RT shed. That is the structure in the deeds. We file an RTI. What is the value of 100 square feet RT shed? In reply, you have received note from the registration office that valuation is around 45 lakhs. We have 45,000. 45,000 is the value of 100 square feet RT shed. That is not Order 41 Rule 27 application. We thought to disclose that document which is received from the Inspector General of
Then that had to be deducted from the market value.
That has to be total value minus the 45,000. That has to be deducted. But the trial court has not gone by that. He has not done the averaging also. What he has done after that, he has said you have asked for 4.5 lakhs, which is not our case. 4.5 lakhs, so I am giving you 4.5 lakhs. That is erroneous because calculation was not done properly. We have said in the pleading 5 lakhs.
No, Order 41 Rule 27. First, let us finish this one.
Kindly take
structure. What are you producing? What are the documents?
Can 2 of 2022, my lord.
No, what are these documents?
One is not the reply, RTI reply from the Additional Register of Assurance 3, which gives the valuation of structure, 100 square feet structure. This is the first document. The other document is, my lord, regarding date of the award, because that was incorrectly taken. They have the trial court has taken the date of the award as 15th of July 2015, which is incorrect, my lord, because they have it was approved on 23rd of February 2016. Approval by the governor. So after that, award has to be published. So we shall get some more interest for that period. That is the second document in my Order 41 Rule 27. This Can 2 in FAT 3 of 2019.
Can 2
into FAT 3 of 2019. These are the two documents. Now, so far as the other point regarding we have not done it after deducting. In the chart that I have handed over to your lordship, my lord, after deducting 45,000, we have not given the value of the deed. If your lordship,
it's about structure.
Structures.
So you concede to that extent that it's with structure, but you say deducted.
Deducted. In the chart, we have given the calculation last two columns, my lord. Market value of structure after deduction of structure and the value of the structure.
Very.
Now, the next point is not that he says that
their sale data was not considered.
Their sale data. That, my lord, that is firstly the grounds of rejection should be, my lord. First is that it is under 26(1)(b). When 1A is available, 1B is to be discarded totally. First ground. Second,
whichever is higher.
Whichever is higher. So 1B, they are saying set forth value, average, 1B valuation comes. And we produce the deeds to show the 1A valuation. So 1A, 1B is to be discarded totally. That is my first ground, my lord, why it should not be considered. Second is, my lord.
No, they also, their registers also showed the market value.
No, they have not considered the market value. While preparing this award, my lord, they have taken the set forth value.
No, the documents they are now seeking to, no, they say that they produced sale data for last 3 years. That sale data showed only the sale prices.
Sale price and the market value also, both.
Therefore, those also showed market value.
That is a document, my lord. All the deeds in the area, they have done average. But if
that's a better indicator than your.
But if 1A and 1B is available, my lord, 1A is to be taken because the law throughout is that, my lord,
yes,
when
even taking 1A, their average should have been taken because those also showed the market.
I say it should not be average, it should be the highest exemplar. That is the law declared by the Supreme Court that when several exemplars are available, then the highest exemplar is to be taken.
If B comes in only, then average. Question of average.
B doesn't come at all, and out
if
of
it came in, then only average would apply.
Average would apply.
Otherwise, if A is there, highest.
Then highest of the area. So that's the one ground. The other ground is that their sale data is erroneous because as per the explanation to section 26, my lord, out of all the sale leads, only top half of is to be taken. If there are 100 sale leads, the 50 sale leads displaying highest value is to be taken. They have not done that. So in any case, it is erroneous. That has been admitted by them in their application. They are now saying that was incorrect. This should be the valuation in this application. So there's an admission in the appeal that was erroneous. That is not Can 4 of 2023, page 11. এটা কোথায় FAT কত ওদের তো in FAT 516 can 4 of 2023. That is the application. At page 11 they have admitted that the calculation is erroneous because they have not taken the top half and the market value should have been taken. So now they are offering something more than what has been offered in that application, but that cannot be done in that way. They have to produce the deeds for consideration. And the other ground is milord, they might say 159 deeds. They have to produce the deeds for consideration of the court. They have not produced a single deed, milord. No pleading and not a single deed produced. Unless the deed is produced, how the court will see whether they are same moja, similar land, nature of transaction, structure is there. Nothing can be seen by the court. So those deeds can, in any case, cannot be relied upon. These are the reasons why their sale data should have been discarded and has been discarded by the court. Now, milord, our 5 deeds I have shown to your lordship, milord. Now I try to show, milord, they have taken a point that these deeds are of land which are not similar in amenities. Now that is also incorrect. I'll show the schedule of the 5 deeds. If your lordship takes up page 142, the 142, page 142 is the first deed, milord. Schedule is at page 153.
Same nature of land. This is in that.
Same nature of land, milord.
So Bandhavata did not argue same nature. He said structure is there.
Structure, mixed class of
He
land.
did not say it is not of same nature.
But this is also
he said not
Vastu
in
land.
vicinity and there is structure. That is the distinction.
Now, kindly see page 153 once, milord. The schedule.
153.
153, milord.
Yes.
3/4 share of Vastu land. So this is Vastu land.
Yes.
Our land, milord, is also Vastu land. So, milord, nature of land is same and schedule is given there on one side there is Chorokdanga road, but the milord map, map আছে whatever the map name. This is 1D. So on one side there is Chorokdanga road, but the other sides are surrounded by lands. Like our case. Our case also it is on the main road. Land is on the main road. 162 এটা কোনটা? Now 162 is not the map of the land. 162. 100 square feet RT shed. Your lordship will find the area of the RT shed.
That corroborates the schedule only. One side road and other side land.
And if your lordship sees the land, milord, the main square land is, milord, not on the main road. There is a passage leading to the land. Not that the main land is situated on the road. A passage which is also part of the land.
But the one which has been acquired is on the main.
On the road. On the road. Now, milord, the other deeds also I'll show.
This is for what project?
This is not there was a squatters colony in Bhadrakali. So it was acquired by the government because there was a litigation. We filed initially for their eviction because government has to return the land. Ultimately,
squatters refugee Bhadrakali women's home.
The government in the court said after the directions of the division that we cannot evict them. There's disruption. We shall acquire the land. So for their rehabilitation, it was acquired. Now
you are the instigator of this entire thing.
We wanted our land back. It was not good.
You got your money. You are entitled to your money.
Getting in tranches, milord. Because the new act came, milord. Now they are getting some 100% solatium and the market value. They are getting some.
So what are your points in your appeal?
My points. No, I'm not showing the schedule of the other deeds. The other deeds also show, milord.
Similar.
So land is similar. Now, milord, errors in the judgment, milord. Milord, firstly, milord, the calculation is perverse. If your lordship comes to, milord, the calculation part of the judgment. To start from 54, ultimately the findings are from page 75, third paragraph. Only one thing, milord, we have pleaded, milord, 5 lakhs per kata. Evidence, we said 5,60,000 per kata. They have taken this point also in the appeal, although they have not argued. 5,60,000 per kata. But before this appellate court, we say it should be the highest exemplar, which is more than 6 lakhs. Now, there are some judgments I have not relied upon, which says that even if a particular amount is pleaded, in case of land acquisition, the court has to assess the just and fair compensation. So it might be above the value pleaded or evidence given. It can be higher than that also. There is no cap or ceiling so far as not awarding the compensation is concerned. That judgment is there. I'll place that judgment. Case 75 kindly comes from the second last paragraph onwards. I'll place.
Yes, yes.
On perusal of the citations, this is regarding higher valuation citations, highest exemplar. On perusal of the citations filed by the present applicant, it is evident that highest market value should be preferred unless there are strong circumstances justifying a different course, even under the provisions of the Land Acquisition Act 1894. I have gone through the MOSA map. The application has referred LR plot number so and so, so and so. All are of Bhadrakali Moja, and all are related to the rate of land value as per kata for the month of June 2011 to September 2011. So as per prudent analysis, after going through the citations, I am of the opinion that it will be wise to accept the referral plots and deeds of the applicant. I have also gone through the arguments along with the written notes and considered, and since I have found no objection from the opposite side, and I also did not find any such infirmity in the submission of the learned counsel for the present applicant, I have no hesitation to take it granted that the demand of the present applicant that the land value shall be 4,50,000 per kata on the basis of average sale value of the deeds filed herewith along with section 26A as deposed by the present applicant. Accordingly, compensation is determined as follows. This was never my case. Pleading was 5 lakhs, evidence was 5,60,000, and if the averaging is done after deducting, that is also more than highest is 636, but if averaging is done, then also it's more than 6 lakhs. So this finding of 4.5 lakhs comes out of nowhere. This is not first error because not correct reflection of my pleading or my prayer.
The average of market, the averaging means regarding the market value as shown in those 5 deeds.
In those 5 deeds as determined by the authorities for getting the revenue, stamp act. In this new act, the two are brought at par. Getting the stamp duty and giving compensation, those were different. Now they have brought at par by this act. Now, my lord, this is the first point, that this is not true reflection of my pleading. I have prayed for much higher. Second point is, my lord, they have not given the interest under section 80 of the act, because only, my lord, 100% solatium and 12% interest has been given till the date of the award, but not from the date of the award up to date of payment. Under section 80, there's an interest element. It was there also previous act also 9%, then 15%. Apart from 12%, additional compensation, this 9% for first year, then not 15% from date of possession or date of notification up to the date of the payment. That part is missing here. So that is the second error. The third error is not the date of interest calculation is erroneous, because the court has taken till 30th of July 2015, but I have shown in my additional evidence application that
taken till
30th July 2015. Court has given up to that date.
Why?
Treating it to be date of award as per their submission, but that is not the date of award.
If your order 4127 comes in,
then not the date on which not the government is saying. I'm just reading this document, my lord. 23rd February 2016. It is not addressed to the DM and collector by the Lord Assistant Secretary to the Government of West Bengal Land Acquisition Branch. The undersigned is directed by the order of the governor to say that the governor is pleased to approve award amounting to rupees 13.95 lakhs, this total land. Only an award note for acquisition of the land mentioned in the subject above. He is now authorized to declare the award immediately. So declaration award has to be after this date, 23rd of February. So we are entitled at least up to this date. So some more days we get. This is not page 13 of our Can 2. So these are the 3 errors. We shall get higher averaging, interest not till date of payment at 9% for the first year and then 15%. And the date, this 12% should be till 23rd of February 2016. These are the 3 grounds, my lord. Now, there's one anomaly. Since it was under new act, my lord, possession was already with the government. So taking possession, because we could not get them vacated, then government came and said that we shall acquire the land. Then the section 11 notification was section section 4 was given.
Where is the High Court order which remanded it?
That order
any
was
specification there regarding this date of from which date it will be calculated?
No, that was not given. Because my as per calculation has to be on the as per the new act, section 11. Here there is no section 11, section 4. So that is the preliminary notification.
So
They have
you are
cal-
agreeable, both of you are agreed
Yes.
on that, the
that
date of
20th September 2011. We are agreeable on that, but not the possession
Interest,
should-
yes, obviously.
possession should be taken from that date only. They have given us rent compensation for the previous period. But if for section 4 is on 20th September under the Land Acquisition Act, and after the award, section 16 possession is taken. In this case, it was already with them. So it should be from the date of notification. This interest, my lord, under section 80 should be from the date of the notification till, my lord, the date of payment at 9% for first year, then 15% for the remaining period.
So that was otherwise given.
No, interest was not given. 80 was not given at all. If your lordship takes up section 80 once, my lord.
Yes.
General interest
Of the new act. Because calculation has to be under new act. When the amount, section 80 my lord.
80 of the new act.
80 of the new act.
Yes.
When the amount of such compensation is not paid or deposited on or before taking possession of the land, collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. Provided that if the such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date or expiry of the said period of 1 year on the amount of compensation or part thereof, which has not been paid or deposited. Here, my lord, possession was throughout with them. That is admitted. So from the date of notification, they should not pay this interest. This has not been given at all. And the 12% which is given, that is under section 72, no? Under 72, no, 72, no, 69. That, my lord, has to be for a further period because it is the date of award has been taken erroneously.
That is under which?
That is not 69. With 100%. Yes, not section 69(2). 69(2). In addition to the market value of the land as above provided, authority shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of publication of the preliminary notification under section 11 in respect of such land to the date of the award. This has been given, but some more days we shall get erroneously. And 80 has not been given at all. 80 আর এটা হলে 8 পাবি নাকি দুটোই পাবি কোটার উপরই তো পাবি তুই
Alright.
So these are the anomalies in the order, and so far as the points taken by Mr. Bandyopadhyay, I think I have covered the points. 2 days after date, I have shown the
Yes.
market price. It has to be market price, cannot be sale price because market price is 1A. Exhibition, I have shown the dates not when it was exhibited. Their sale data is to be discarded. Reference deeds are far away. Land with structure, we have given them a structure value. And what they have now acquired, that is not.
What about their order for 2027? They are seeking to.
They're seeking to incorporate that. Now,
assessments.
They have not produced the deeds before the court. They cannot not change the rate report. Award has been given. They cannot give a substituted award now. Now they can produce documents on the basis of which the court will ascertain. They cannot re-ascertain.
No.
They have ascertained that has been challenged in
They're doing that. They're producing assessment slips.
Assessment register of the deeds of the area. Now they have to show the deeds to.
So the same argument as their document in the code will.
And not only the highest example, few judgments will not. I'll just say the proposition and Junior will hand over the judgments. First proposition is not if the.
1 minute, just.
জাজমেন্ট গুলো কোথায় আছে বলতো খুঁজে বার করে আছে ওখানে পরে খুঁজে দিস
Yes.
The first proposition is not that if several exemplars are produced before the court, the highest exemplar is to be taken. That is the first proposition. I have relied on some judgments in my notes, which is filed. I'll give provide other copies. Starting from 69.
Not with us.
No,
You could not find out those notes. So take out photocopies and give us.
I'll take out photocopies, the entire one.
Photocopies will do.
I think I can find it because it was definitely filed, most possibly somewhere lost in some paper. I'll try to ascertain, otherwise I'll give photocopies. So that is the first proposition, that highest exemplar is to be taken. So if our
How
deeds
many
are-
judgments have you said?
No, there are not 4 judgments on this proposition. The same proposition. I should not,
Anyway, what is the
any one will do, Milord. That highest is to be taken. Next is, Milord, irrespective of the pleading, court has to assess the just and fair compensation. This, Milord, 2016 volume 4 SCC, page 554. Because we have pleaded 5 lakhs and in evidence we have said 5.6 lakhs, but the court should assess on the
Yes,
basis
in case of compensations, court is.
there is no ceiling, no upper cap. Then, Milord, next is, Milord, evidence without pleading cannot be looked into. So whatever evidence they now seek to produce, Milord, that is without any pleading in support of that. Evidence.
How many judgments have you cited on? Evidence
Two judgments on that proposition also, Milord.
Anyway.
The same proposition. Only these
That's
3
it.
propositions of law, Milord. So on these, Milord, my deeds should be considered and average, proper average. My case is highest. If the court is of the opinion that the judgment say, if the court is of the opinion that some particular deed is much higher than the other deeds, it may be discarded.
Yes.
But normally, if there is strong circumstances,
Disparity, yes.
My lord, disparity there. So, my lord, my deeds should be considered. They are not within time and market value. So, if it is market value, in that case, my lord, the concept that deeds are prior or subsequent does not come, because they have to show that there was a revision in between in the registrar's office. Unless there is a revision, then it is same in spite of the acquisition. So these are my points, my lord.
Yes, in reply, Mr. Bandhu. Reply. They have taken, Mr. Bandhu, Banerjee has taken 3 points in his arguments. In his appeal, in support of his appeal, calculation is perverse, because 4.5 lakh was held in page 76. 4.5 lakh was not even their pleading, and they have cited judgments to say the highest exemplar to take. The second one is that this section 80 interest has not been given. Third one is date of interest taken to be 30th of July 2015.
And in this regard, my submission is this, my lord. Due to, my lord, that matter was sub judice before this honorable court. It is, my lord, the land division case of 2011-2012. They have challenged before this honorable. And it, my lord, ends in the year 2016. Thereafter, my lord, it, my lord, again, my lord, therefore they are not entitled to get, due to, my lord, this period, my lord.
No, they are only saying that the date of award should be taken when the governor approved. That is 23rd of February 2016. Not because of their pendency.
My lord. Not prior
say,
from the
even
date
if they didn't prefer a section 18, then also the date would be the governor's approval date.
My lord.
Litigation period has been excluded in the order. The litigation period has been excluded.
So they are not taking advantage of even without their litigation. If there was no litigation, if you understood Mr. Banerjee correctly, 23rd February would be the date.
My lord.
Litigation period obviously has to be.
That
probably has been.
Page 77, litigation has been excluded while calculating. Page 77, if lordship comes.
Therefore, they are not entitled to get the interest for that period.
No, section 80, this will not come. Section 80, they have to deposit at the beginning. They have to deposit the compensation money. They have not deposited. 77, lordship sees not the section 72 calculation. Here, my lord, the period of litigation is 5 years from 12 to 16. So that has been. Total period 7 minus litigation 5.
Yes.
That has been excluded so far as section 72 is concerned. 69. So far as section 69, it is excluded. But 80 possibly it should not be, because they have to deposit the money. Okay.
The concluding arguments. Good. Thank you.
We are, my lord, not filed our opposition to the order 41 of their.
Order 41 will consider on the criteria of order 41.
No, it has been.
আমরা দিই না আমাদেরটা দেওয়া হয় না আমাদেরটা আমাদের কাছেই রয়ে গেছে
Affidavit in opposition filed in respect of the application. Affidavit in opposition filed in respect of the application under order 41 rule 27 of the claimant. Claimants, comma, on behalf of the state, comma, be kept on record. Hearing is concluded in the matter. Judgment is reserved.
Much obliged.
Your written notes.
No, I'll get it. Not,
We have also
I'll just
your notes.
check
We have.
once,
Oh,
I'll check
character
once.
line add kodin. Written notes of arguments filed by the state/land acquisition collector be kept on record.
I'll file mine also, my lord, because I'll check. Otherwise, I'll get a Xerox and file. I have the copy. Xerox code. I'm filing by course of this day.
Yes. এটা দিয়ে দেবেন। এই বইগুলো পাঠিয়ে দেবেন শুনুন। হ্যাঁ হ্যাঁ কিন্তু লাগবে না। তাহলে পল্লবকে বইয়ের নামগুলো দিয়ে বলবেন লাইব্রেরি থেকে তুলি এর সঙ্গে ঢুকিয়ে দিন। আমার পিএ কে বলবেন এই বইগুলো ফোন করে বলে দেবেন এই বইগুলো নোট একটা স্লিপে লিখে দিন ওগুলো যাতে ও ঢুকিয়ে দেয়।
But I was addressing
Yes,
about
Mr. Sarkar.
but on the last occasion, I have indicated to them that my client is willing to purchase the shop.
Yes. What
So
about that?
they
Offered something.
they offered something yesterday evening. The party sat together. If you also give us some time,
Definitely. We'll keep it after the vacation.
not so long, my lord.
Not so long.
Not so long.
When? Tell us.
Monday week, subject to or Thursday.
Monday week is a holiday.
Thursday week.
Very well. Learned counsel for the parties submit that there is a that the parties are trying to negotiate on the offer of purchase made by the appellant. You're for the appellant. By the appellant.
Actually, there are two appeals.
You're for the respondent.
Lordship, a plaintiff defendant.
What is your name? Your party.
Wadwana.
Wadwana. Offer made by the appellant respondent na kore offered by
Wadwana.
Messrs. Wadwana. Full stop. Accordingly, on the prayer of counsel, comma, let the matter stand adjourned till May 15, 2025, when it will be listed under the same heading.
I'm
May
deeply
15 is Thursday week.
Lordship, I'm deeply upset.
Thank you.
Well, his litigation going for 40 years. If it is
If you
settled,
can
my lord,
use your good offices, Mr. Sarkar and Mr. Banerjee, it would be the best thing for the clients.
Lordship,
Absolutely. Yes. Mr. Trivedi, you have to take a clue from the previous matter, the length of arguments.
My lord, length
They
of
were,
arg-
both
my lord,
of them
I
were
will-
excellent. I mean, need not be so short. I mean, but
Here, my lord, one application has been filed by my learned friend.
One application.
that will
Additional
reject.
evidence, no. we
That
have
you
not
can
rejected.
reject so that you can take up the action. What application?
Order 41 Rule 27,
Oh,
which will be decided.
you grow wiser. All of you grow wiser after the matter comes up for hearing.
Because we have learned from my lord.
I'll be using a
No, you have never learned from me.
I have always learned.
No. Order 41 Rule 27, I never find after hearing.
Online hai. Online hai.
Order 41 Rule 27 application should be filed prior to the hearing at least.
But this is not.
My lord,
why
I
they are
have become
filing the
wiser. My lord,
ground-
why when
They want to take away the ground of not the judgment. The ground is that not they have not deposed in spite of giving opportunity. They have not deposed in support of their case.
Oh, now
That is
they're
the ground. They
trying
want to now depose by way of this. Now, I'll be using a short affidavit to that, my lord. Because
तो
there should be.
आज की affidavit देबे.
No,
Okay.
I'm
My
filing
lord,
for
this is-
my lord, 3
10
points.
days
I will
time
try
to give
to.
my opposition.
My lord will kindly not adjourn it for 10 days. My lord will kindly just let.
We'll adjourn it for more because they'll take 10 days and
my
we'll
lord will
file
allow
reply.
me to just open my case for 1 minute, just one.
We'll
minute.
not keep it part-heard.
No, my lord, not part-heard. I am never on not on that. Why I am telling you, my lord, if my lord, I want an additional direction from my lord. What has happened, my lord, while reading the judgment as far an affidavit in chief, I find that there is either discrepancy in the paper book while typing it because
That will have
the
to check.
number of exhibits which have been marked as exhibit as per order sheet, as per the affidavit of evidence
check.
and cross-examination is only 4.
Mr.
While
they go through the records.
my lord, records have not come from the trial court.
Because by consent on their prayer, it
Yes,
was
that
dispensed
was
with.
that was a
Now
folly.
at the time of hearing,
My lord,
kindly
what
comes to the
happens
order
is-
dated 1st of September. Because it was dispensed with, we obtained entire certificate copy of the entire documents and incorporated. And we have also supplied the entire order sheet to my learned friend.
Yes, he has been very
Because-
kind.
Because otherwise these points will come up.
So
I am
He's saying that they do not tally the order sheet.
No, my lord, it does not. My lord will kindly just for
Let
one,
them
1 minute,
update the
let me,
certificate copy and show it, my lord.
Mr. Trivedi, just have a sitting with Mr. Banerjee or
He's a widow, my lord, who is not fighting
you
till
can
date, my
freeze
lord,
out
for
on these
my lord,
things.
just
Court
for
need not
the-
waste its time on these
because
things.
look, my lord will
You just
kindly see, because
just
it will
squeeze out the
strike at the
difficulties.
very root, because what my learned
Mr. Trivedi, let us
Lodge.
hear us for a minute.
Lodge, I apologize.
All the certified copies are here before us.
Only order sheet.
No, no,
No, the
records
documents also.
Documents also.
My lord, certified
I filed
copies
the-
of
The exhibit copies also they have
my lord,
filed.
no, my lord. There were a
Which are not there.
bundle of documents were filed, but the affidavit of evidence shows the initial dispute for not deposing on behalf of the union was that we objected to marking of documents which were actually
Where is the part
photostat.
2? There is a part 2.
My lord will kindly
Where are
first,
the exhibits?
my lord will
All the
kindly,
exhibits are not in the form of paper books ready and the certificate copy, but not. I'll have
it
to
is not
file that before
certified
court.
copy. My lord will
File.
kindly first
So
take up
give
the
a copy
paper
to them
copy.
also.
Yeah, I've handed over a copy.
My lord will
Already
kindly
given.
once
So we
allow.
won't tally. Mr. Trivedi, we won't be tallying documents.
No,
here.
my lord, I'm
Sorry.
not wanting, my lord.
You
I
just
have
have it
just-
between yourselves, and whatever is the issue, just point out to Mr.
Fine.
Banerjee so that
Let
it
them
can be
point out
resolved
the
before you
anomaly.
come.
Issue is only
In any event, you have to direct them to file
my
affidavit.
lord,
in
issue is
opposition.
only one. I am submitting before my lords so
No,
that
not that issue. Mr. Trivedi, you say that there is the documents do not tally with the order sheets or the marking of exhibits.
yes, my lord, because there is not because the documents
We are
I have
telling
also
you
gone
just
through.
have a sitting with them so that you can resolve the issues. If there is actual discrepancy, point it out to us. We'll consider that. One. Secondly, your order for Rule 27 has been filed only now. So they are entitled to opposition. We'll give them that time. And if you want to file a reply, you can. Or if you don't want, don't file.
No, my lord, I will.
We'll give them a.
Let him show the anomalies. I shall try to, because
Today we are on 1st. So we'll give you till 13th.
13th of June, my lord.
30th of May
June
for opposition.
opposition. May.
Opposition. And you will file your opposition by 20th of May. Your reply.
Reply, my lord.
And resolve these things in the meantime and come back immediately after the vacation. We'll give it after that.
Lodge will keep it 1 week after the vacation, my lords.
Where are you going?
My lord, I'm
Depending on-
going up, but
We
my
will
lord,
reopening, because not these are ladies
Inside or outside?
who is not fighting for the
Yeah.
legal fees of our husband.
Inside, then we'll keep it after immediately after
no,
the.
my lord,
If it's outside,
no, my
abroad,
lord, I don't go outside. After 22, I'll stop going.
after 22 years of age.
No, my lord, after 2022, I'll stop.
I thought there was some jinx with 22
No.
years. Something happened.
No, my lord.
So very well. Mr. Banerjee, you are sure you are not going out anywhere?
No.
So then we'll keep it immediately after the reopening.
Yes.
We'll keep it in the monthly list of June.
I'm
itself.
going.
If you have any difficulty, always you can come in.
Fine.
The appellants seek to rely on an application under Order 41 Rule 27 of the Code of Civil Procedure filed at the hearing stage. First up, learned senior counsel appearing.
Lord, may I submit this? Let the, if you want, kindly direct the LCR to be brought.
That is my
Because they are
only,
taking-
because
they are taking an
LCR, if
issue,
it comes,
I have
that,
no problem with
yes.
that. Let the LCR then.
I am just wanting
Let
LCR
it be, let it be in the
Very
monthly
well,
list of
very
not,
of course.
Learned senior counsel appearing for the learned counsel for the respondent seeks an opportunity to file opposition against the said application. First, accordingly, the respondents are directed to file their affidavit in opposition to the application under Order 41 Rule 27 of the Code of Civil Procedure within May 13, 2025. First up, reply, if any, shall be filed by May 20, 2025. First up, on the prayer of learned counsel for the appellants, comma, the trial court records be called for by special messenger at the cost of the appellant.
So we'll put
We
in the
shall
post within 1 week, my lord.
We shall be deposited.
I mean,
Not 1 week. Put it from a pocket.
My lord, I will put it from my pocket only, but my lord, otherwise, if I ask
my
Union
client
of
is
India,
suffering.
To be deposited within a week from date. First up, next para.
Kindly consider the nature of the matter. তুমি তাড়াতাড়ি করে দাও।
Upon the records
সে মরেই গেল, পয়সা পাবে।
arriving before this court and being examined and found to be complete, comma, the office shall furnish a report to that effect. First up, next para. Then it cannot be taken up in the first week.
That is
We will keep it in the monthly list of July then. Which court?
Alipur,
Alipur,
it can be
Alipur.
brought, my lord. Special messenger, Alipur court can be
Very
brought. Let it be there.
if my lord keeps
let-
it in the
let the-
second week only, also,
Let
my
the
lord,
appeal be listed next under the same heading on June 19, 2025. That's the hearing date, June 19th.
my lord. I'm grateful.
Thank you. Nowadays you are grateful, Mr. Trivedi. Where has
My
your
lord,
indebtedness gone?
online,
Previously you used to be indebted.
my lord, we are online, my lord. The child again in me, the exuberance will come out. Therefore, I'm
No, come out of the cradle now.
My lord, there are some people with whom you feel very nostalgic and very childish and exuberant.
I'm gone. If you are gone, then I am gone after this. We are online, and if you
So, my lord,
get caught
my
to
lord
one of
is
us-
one of them. My lord knows it from my nature, right from college days. So therefore, my lord, because we are online, my lord, therefore I behave in that manner only with your
So you
lordship.
start with a handicap in your appeal, if that be so. We'll come back for the next one. This one.
Lordship, under complaints, in the morning I mentioned, my lord, I went to the department, my lord, they are not accepting without the certified copy. Your lordship grant me leave to file this, my lord.
Certified copy of the appeal court's judgment is there.
This is there, but my lord, the trial court is not there. We have applied for, my lord, so
Appeal
that
court's judgment certified
yes,
copy
yes,
is there.
that is there.
They are bound to accept.
My lord, they are not
To,
accepting.
Engage a proper clerk.
My lord, I have gone to the court master, my lord. They are not.
No. We won't go to the department and direct them.
My lord, department, I went to the.
Sorry,
department.
please don't disturb the court, Mr. Mondal.
My lord, I don't want to.
There's a limit to everything. We have told you, judgment, if judgment certificate copy is there, first appellate court, they are bound to accept.
They are not.
Why no leave is required? Why should I give you leave? Call on them next man.
Saying that my lord, the trial.
Please
court,
stop.
without the trial court saying they will not.
Please
take
stop.
it. হ্যাঁ
আমি সেদিন করেছি আমি
স্যার নিচ্ছেন আমি এতক্ষণ দিয়ে এখন ওনাদের সঙ্গে এইটাই
Yes.
ডিফেক্টিভ থাকে
ডিফেক্টিভ বলছে আমরা ফাইলিং এ নেবো না
হয়ে যাবে যা মানে ইন দিস ম্যাটার my lord on sometimes my lord the department my lord the computer section my lord is
Computer section নিচ্ছে না কি বলছে দেখুন তো।
my lord putting the various questions my lord they are not then my lord we have to move go there and
আচ্ছা তাহলে ঠিক আছে তাহলে কাজ করুন
junior
কম্পিউটার সেকশনে কি আছে ও তো বলছে ছেলেটা বারবার একবার কাউকে পাঠিয়ে হ্যাঁ যে আছে কম্পিউটার সেকশনে তাকে নিয়ে আসছে ইউ শো আস দ্যাট কপি দেখি একবার উচ্ছেদ হয়ে যায় মুখে তারপর
computer section
সার্টিফিকেট কপি রয়েছে they are bound to accept
right my lord
why would I disturb your
there will be no defective
I see
yes defective right
I said that your lordship has it is for fallen from your lordship it will be defective but they saying that
let them come let them you be here
বলছে আমরা ফাইলিং নেবো না উইদাউট সার্টিফিকেট কপি অফ দ্য ট্রায়াল
দাঁড়া
এটা একটু ওনাকে দিয়ে দিন you keep it with you and stay here let them come
সার্টিফাইড কপি অরিজিনাল নেই নাকি
না
original certificate copy of appeal first appellate court they're bound to accept it will be defective
not original it's
না অ্যাপ্লাই
certified copy original that is the trial court you are seeing you have annexed it incorrectly that's why probably they have missed it out
no
first appellate court will be above
yes your lordship
the judgment listen to us
yes your lordship
the memo will be the first thing in that bunch the second will be the first appellate court's judgment then trial court's judgment first appellate court decree trial court's decree this is the order you have annexed it wrong you have annexed the trial court first
yesterday what I have done my lord I have chronologically appended those documents chronologically but they said not now the rules
then we have to go to the department and
I
why are you disturbing the court limit please wait for some time we have called for them
I wait
and don't do this again Mr. Mondal if there's a problem contact some good clerk you cannot disturb the court like this day in and day out you cannot do this we are giving you this last warning on this we are not here to do these things yes call on the list 16 to 24 Mr. Dattu you are
in this matter very short issue in all but in this matter my lord I am not opening my brief but in this matter my lord trial court passed the judgment on the basis of the earlier judgment
একটা শুনে নিন উনি কি বলছে তারপর দরকার
মানে first paper book you also can take it মানে without any evidence that trial court without any evidence cannot
this was not led by you that's why
no they have not deposed
they have not
plaintiff has not deposed
acha you have deposed
neither party deposed
so should we remand it for
that's once this judgment has been rendered by this
judgment given without
this is the judgment my line friend was other side in the court number 8 similar issue
no that I give a concession no problem similar issue here is not
how could the court pass the judgment then
without tendering document without nothing
I am taking 5 minutes time a chunk of about 12 acres of land was acquired then out of that 10 acres belong to a company other belongs to individual persons now so far as 10 acres land is concerned then the reference code was there reference code evidence were used reference code assessed compensation at the rate of about 60 lakhs per kata 60,000 per kata then government came in appeal in high court then the company the referring claimant filed cross objection ultimately cross objection was deciding assessing about 1 lakh per kata now that matter went up to Supreme Court dismissed the appeal now after that the other co-owners who were the landowners of the remaining portion about 2 acres various persons are there but their reference cases were taken up No matter what happened, in course of hearing, without adducing any evidence, first they filed by way of a firisti the certified copy of the judgment passed by the trial court, reference court, by which 60,000 patha or not 62 or like that, that was assessed. Then, my lord, at the time of hearing, he filed the certified copy of the judgment of High Court as well as the dismissal of the Supreme Court. So it is not that my learned friend may be correct, my lord, that there is no evidence. Only thing, those documents are certified copies are there in the file, and on the basis, and there is no dispute that the property is covered by the same notification for acquisition.
Very well, but
Covered by same notification for acquisition. Your lordship also
so you
knows
say on the basis of the documents which were there before in the previous matter,
that has been filed in the court. With the only thing my learned friend is saying,
not tendered in.
not tendered in evidence. A certified copy of the judgment of all the judgment. And your lordship knows, my lord, very
Not
well.
regarding certified copy, the sale deeds were not produced. You say
No, it is not necessary sale deed.
on the basis of
On
those
the basis
judgments,
of only judgment passed by
will be the
this
standard
court
of
after-
assessment.
only on the basis of the judgment, as per the valuation and assessment.
Then Mr. Dattu,
My lord,
Oh, that's why,
everything-
just a minute, that's why, in order to avoid difficulty, I have once again come up with an application for additional evidence annexing those documents. Those three judgments, judgment of trial court, judgment of High
those were
Court
there, you were saying before the court below.
Mira?
You say those judgments were there before the court below.
below.
So why have you filed another order for 2027?
Because those are not tendered in evidence.
Certified copy we are lenient.
That is all.
My lord, that's not, my lord, my
that's
lord,
the-
only,
no
my lord, only Supreme Court
necessary-
held.
No necessity.
Supreme Court held that they have to come in the witness box and they have to tender the document, and this procedure, my lord, pleadings and proof. My lord, without, my lord, evidence, my lord, they may win, but they.
We understand, Mr.
But
Mr.
that's
Very well, Mr.
Well,
Dattu,
similar
we propose to then allow this order for 2027 application and then
well,
we
similar,
can take up.
then judgment on admission that may be, but not judgment on contest, my lord.
Order for 2027 if
My
we
lord,
allow,
Huh.
if those, because those documents were there before the trial court. If
my
we
lord,
allow this,
that's why, my
these
lord,
are certified copies.
All certified
Formal
copies.
proof will dispense with and we
Yes.
will take up the matter and
My lord,
affirm the judgment then.
But I want to realize the judgment of the Supreme Court, my lord. Then, my lord, the Supreme Court held that matter be remanded to the trial court for decision, my lord. This is 2022 voluntary civil Supreme Court. Order for rule 27 allowed the
But that is not in this matter. কিরকম, like
না, আমি তো বলতে দিন, আপনি তো
ঠিক
বলছেন,
আছে, বলুন, বলুন, বলুন।
আপনি তো বলতে দেন না কাউকে মুশকিল।
Yes, Mr. Bera, this
Allegation তো করেন আপনি,
this
আপনি
is
তো বলতে
a
দেন।
serious allegation against you.
I am silly.
This was the purpose of Mr. Dattu, so that you sit down. Don't sit down.
Yes, I am silly. I am silly.
My lord, paragraph 13 to 21, my lord,
I am interactive. Like a senior advocate after so many years practice, he is not even referring the judgment which he wants to rely upon. This is the standard of.
no, my lord, my lord, 2022, my lord.
Standard.
My lord, sorry, my lord, there may be wrong judgment, my lord, given, my lord. The 2022, এখন
We have got two judgments. 2022 to ICC 746, Sanjay Kumar Singh.
yes,
The other is Vishwanath Bonik versus
my lord, that judgment is not required, my lord.
Vishwanath Bonik we return.
Yes.
Sanjay Singh we have. We'll keep it.
Sanjay Singh,
What is that?
Sanjay Singh, my lord.
Sanjay Singh we have.
ও দুটো আছে?
এটা ফেরত দিন। এটা বিশ্বনাথ বণিকটা ফেরত দিন। এই দেখুন, জজ সাহেব এটা নিয়ে নিন। Yes. Order for 2027.
Order 41, Rule 27, my lord. You will also kindly consider paragraph paragraph
No, cannot be straight away exhibited, definitely.
no, my lord, paragraph 3.1, my lord. First, you will also kindly consider.
Proposition is there, Mr. in para
Right.
6, Mr. Dattu, that allowing all application under order for 2027 does not lead to result that additional documents can be straight away exhibited. Rather, applicant would have not only to prove existence, authenticity, and genuineness, but also contents thereof.
Well, that's why the Honorable Supreme Court, my lord, remanded the matter to the trial court for taking up the document, and your lordship knows it very, very well that
even order for
Mr. Dotto, these are certified copies of judgments.
but the my lord,
Certified copies of public
my lord,
records.
the plaintiff has to come in the witness box to say that this is my case. That maybe, my lord, their identity may be challenged.
Whose identity?
Plaintiff's identity.
They are producing certified copies of
Not-
public
not-
records.
not regarding
Plaintiff is not even record. Then the Supreme Court judges who authored the judgment, they have to come and prove.
My lord, your
If
lordship,
argument is taken to
my
its
lord,
head.
lordship, as per provisions order 6, rule 2, my lord, the pleadings and then my lord proof. They have to come, at least, my lord, they have to tender evidence, and they even your lordship can take out that evidence here.
We will do that.
But it is not, my lord, they have to come. It is their document. They have to tender. Otherwise, how the
Evidence act in.
plaintiff's pleadings, they have to come in the witness box and to say this is my pleadings. Similar issues, my lord, involving
Pleadings, they need not come to the box. Pleadings, they have pleadings are there must be. They are the claimants. There must be pleadings on record.
Pleadings on record.
Judgments of courts need not be cited in pleadings.
Not judgment, not matter what firstly, my lord, they have
Proof need not be pleaded.
my lord, firstly, my lord, they have to say this is my case.
Yes.
They have not come in the witness box.
They produce certified copies of judgments.
They have not in the my lord, in the impugned judgment, there is no reflection to that effect. And my lord, your lordship, kindly consider the other bench, other division bench, my lord, this situation arose. The matter was remanded. My learned friend was the other side. I have handed up the judge that order, my lord. Only short point remanded.
That is the other division bench judgment is not a proposition of law.
No,
that
not
in
for-
every case it should be done.
Similar situation arose. They did not depose, and they accepted that I have.
No, here they have produced the judgments in the court below. Not a similar situation. There no evidence was at all given.
No evidence. There it is yours, my lord. They have
Certified copies of judgments every
they have filed by Firistry, but that judgment, my lord, is to be my lord, come in the my lord, evidence, my lord. They have to say that this is the judgment we have filed that may be marked as exhibits. They have to say.
In this case, the trial court dealt with those judgments. Let us see the judgment.
এখানে এখানে can you speak of the right to cross-examine and character of the comparable sale deeds ছিল এখানে registered instruments প্রডিউস করতে চেয়েছি তখন ছিল ডেফিনেটলি registered instrument প্রডিউস করতে গেলে আমরা এখানে শুধু সার্টিফিকেট কপি অফ জাজমেন্ট গুলো করছে টেবিল ট্রায়াল কোর্ট দেখে চাই
Let us see the judgment, Mr. Datta. Impugned judgment. That was a different case. Their sale deeds were sought to be exhibited.
That's why I agreed.
Which is quite different from the present case. What are you saying?
110.
Yes, 110.
My lord, page 112.
Yes.
Points for determination. Whether the acquisition collector, North 24 Parganas, has correctly ascertained the market value of the acquired land. Whether the claimants are entitled to enhancement of compensation, if so, what extent. Whether referring claimants are entitled to get the relief provided under sections under the judgment passed in this court on such and such, LRA case number such and such. This is the totality of the issues. In paragraph 8, they have the trial court held that LRA case number 18 of 2002 succeed in part on contest and contest and merit. The valuation of the acquired lands, those are Bastu such and such, calculated are
these cases, the previous cases, Mr. Dotto, these were regarding lands in the vicinity, the same acquisition process. Same acquisition, same notification. That was only a big company probably, and these are individuals.
Company case was decided first. It went up to Supreme Court. Thereafter, the
other landowners covered by
Say
same
doctor, the same yardsticks will apply.
also
Whatever the High Court held, where is the dispute there? What evidence is required to be laid further?
It is my learnings, my lord. I may be wrong, my lord.
What is your learning?
I may be wrong, my lord. The similar things, my lord, the plaintiff for this purpose must have to come in the witness box and to say that this is my document.
They're not relying on any further
Otherwise,
document at all.
Otherwise, they have to file application under Order 12 Rule 6.
Order 12 Rule 6.
Judgment on admission.
Where is the admission here?
Well, this is admitted documents.
What are you saying?
But we are not denying that their judgment. If they do not come in the witness box, how the court can deal with their pleadings? I may be wrong, your lordship kindly decide. Their longest judgment, my lord.
আমরা যেহেতু জাজমেন্ট অরিজিনালটা তো পাবো না, আমরা রেকর্ড করতে
On merits, my learned friend is right.
In the trial court, you did not produce certified copies. You produced photocopies of the certified copies.
certified copy, page 106. I think certified copies are filed. It can be trial court records.
All the matters were taken up together by the trial court.
Yes, all the matters by common judgment. By common judgment. But written notes are there.
আমাদের তো অর্ডার করতে 27 আমাদের রিটার্নমেন্ট ওখানে যদি প্রডিউস করতে একটা ম্যাটারে যদি অ্যানালগাস হিয়ারিং তাহলে যদি সার্টিফাইড করে প্রডিউস সেম ল্যান্ড সেম নোটিফিকেশন সেম অ্যাপ্লিকেশন এগুলো যদি ওর সঙ্গে শুনানি হতো তাহলে তো একসঙ্গে হয়ে যেত।
দেখছি certified copy. Certified copy of High Court judgment.
High Court judgment is a relevant one.
Yes, High Court judgment is relevant.
Because it's not in dispute that Supreme Court did not interfere.
Yes, this Supreme Court order is also there. That is also
One line order, yes.
This is the certified copy along with the written notes file. Original certified.
Yes, show it to Mr. Dattocci.
Trial court.
Trial court record. Record of trial.
Trial court record.
But since not adduced, but tender, that's why I have come up with order 41 root practitioner to avoid me the difficult problem.
তাহলে আমরা তাহলে কিছুই না, তাহলে একদিন এখানে বক্সে দাঁড় করি প্রিন্টিভ প্রুফ করে দেবে এটা।
And while Lanford is saying 28A clearly speaks after amendment of 1984. It must be covered. If no reference is even filed, they can approach the collector to have the benefit of they are decided in other case. It is covered by same notification. Kindly have a look to 28A.
Mr. Datta, are you disputing these
Land Acquisition Act?
disputing these judgments that these are not there? You did not dispute in the court below. That's why you are asking him.
My lord, your lordship is perfectly right.
We just have to
My
call
lord,
the one of the claimants.
My
We
lord,
take it up analogous.
My lord, with the proposition of law, my lord, judgment of the High Court is binding upon
Yes.
My lord,
227
similar
read with
situation,
yes.
analogous hearing, similar situation, the judgment is binding effect. But only thing, my lord, only
Then
short.
what we have to do is one of the claimants have to come and we have to
Yes.
put him on the box
Right.
and tender the certified copy and
Right.
say that he is there.
Right.
Unnecessary formality.
My lord, this is my lord, for my lord, my lord,
Some formalities go to the root of the matter, Mr. Dotto.
my lord,
Some
only
formalities are cosmetic. We have to distinguish between the two.
right, your lordship. I cannot say my case is, my lord, I am always, my lord,
Justice Biswajit Basu had shared a very good joke with us. He went to some bank. There was an online assistance booth. So there you had to approach, not online, phone banking. So Justice Basu, then Mr. Basu approached the lady and said that I have this problem. How do I solve it? According to Justice Basu, which is not correct, it was a joke. She said that please take out your phone, call me from here, and if you call only, then I'll answer because I am an online assistance booth. So that's a technicality. She was an online assistant. But just because she's an online assistant, that does not mean that if somebody comes in person, she won't take it. The judgments are there. Only calling this poor person from his village and he'll have to come and say, this is the certified copy. All of you know that it's a certified copy. He's the only person who does not know that it's a certified copy of what judgment. But he'll have to prove it and we'll have to take it. The unnecessary rigmarole.
Right,
What is the English of Ghuriye Naak Dekhano? We don't know the English of.
This will be a precedent, my lord, that
let it be a precedent. Let it be a precedent.
But,
let it be a bad precedent. We just challenge it in Supreme.
No,
State has the wherewithal.
Your lordship's view is perfectly right. I cannot say I am.
No, we'll distinguish. Mr. Datta, you are right. We'll record your argument. You have a point on law. You are perfectly right on law. But we'll go on equity and we'll say that there are certain formalities. Just what we said to you, we'll say that only.
So what I have seen from the Supreme Court judgment, if the order 41 rule is allowed, that may be remanded to the trial court.
We'll record those. But we'll affirm this judgment on the ground. Right now, we'll do it. Yes.
And my lord, they are my lord, if the cross objection,
there's a cross objection or
they are claiming enhancement.
There's a cross objection.
No. In this case, I have not.
Just because Mr. is there, there has to be a cross objection.
No, only order 41 rule 27 to avoid.
We'll say order 41 rule 27 is not necessary.
That is there because only to avoid. That's why my argument did not use any opposition to that.
No, Mr. Datta knows the law very well.
Yes,
there is no doubt on that.
Well.
He knows, but whatever he had to argue, he has argued.
He much conversion to the civil, much more.
But I am running into the adverse situation always.
You fight out who is the more learned, and we'll pass for that.
Only one thing I must point out, we have also filed 2 applications. One application was for
substitution.
Substitution, one substitution.
Substitution has to be allowed first.
Substitution has to be allowed.
There are 2 applications.
আছে? Application
এখানে allow হয়ে গেছে?
লিস্টে আছে?
না। এমনি allow হয়েছে?
No, not in all cases, only one কোটা কেসে আছে। allow হয়ে গেছে।
দেখে নাও যে না থাকলে পরে গন্ডগোল হয়ে
যাবে। No, substitution ফাইলটা করতে।
দুটো সাবস্টিটিউশন ছিল।
একটা হচ্ছে আর সেটা ছাড়ো না, সাবস্টিটিউশন পেন্ডিং আছে কি?
দেখে নাও।
After this interim stage are completed, the court ultimately, the collector deposited a digital amount according to their own calculation. Now, according to us, the calculation was not correct, so they deposited certain amount as the digital amount in pursuant to the order of this court as a condition precedent of the state. Number, they have deposited. Number, we have come up with 3 applications to allow us to withdraw portion of the amount that is before the appeal, to allow us to withdraw portion of the appeal and to deposit the balance digital amount. Now, since your lordships are deciding the appeal, so my lord, only will allow us to the amount which has been deposited and the balance amount, if any, that will be executed. That balance cap, if any, that will be done in the executing court. That lastly your lordships will consider.
So what about substitution?
No, substitution no pending. Substitution not pending.
Pending নেই তো দেখি না। আমি দেখছিলাম দুটো কপি আছে আমার।
There are 3 applications. Can 5, 6, 7?
But that is the substitution which has been allowed, that has been filed by the state's application.
না আমি কোনো অ্যাপ্লিকেশন সাবস্টিটিউশন ফাইল করিনি। আপনারা ফাইল করেছেন সাবস্টিটিউশন।
And one is order for 27. What are the other ones? Can 6 is for appropriate order, whatever that means.
Can 6, 7 are
directing to deposit that balance dictatal amount and all this things.
Yes.
So that we are deciding the appeal.
For appropriate order, 7 is for appropriate order, or 8 is application for.
8 is for inappropriate order.
8 is for.
That was for inappropriate order because the others are for appropriate. That is the only inappropriate application. Yes, to withdraw and all.
Yes, 7 withdraw, 6 is deposit.
8
and
is for
8
addition.
They are the three applications. 9 তো দেখি একবার। দেখি
আর 9 ও আছে।
সবগুলো ম্যাটার এসছে কি? আগে একদিন কোনটা আউট হয়ে
9 ও আছে।
I have not received all copies. সমস্ত কপি আপনাকে দেওয়া আছে।
না,
এরকে দেওয়া আছে।
9 আছে।
না একটাই দিন।
FAT 610 में আছে करना है।
610।
No substitution petitions are pending. Whatever substitution that has
So
been
all
done-
other applications will dispose of along with the appeal.
Yes.
The present set of appeals have been preferred. Please take your seats, all of you. The present set of appeals has been preferred by different claimants. By the state of West Bengal against orders passed for enhancement under section 18 of the Land Acquisition Act, for the arising out of the same notification as well as the same process of acquisition. Full stop. Next para. Learned counsel for the state, at the outset, points out that the learned trial judge passed the impugned judgments in all the matters on the basis of no admissible evidence at all, since no document was exhibited by either of the parties in the court below. Full stop. Next para. Learned counsel submits that although certified copies of 3 judgments were produced in the court below, those judgments were not formally proved by way of evidence, nor marked as exhibits. First up, as such, it is contended that the impugned judgments and decrees in all the matters are vitiated by contravention of the provisions of the Indian Evidence Act 1872 as well as the Code of Civil Procedure, insofar as the judgments are based on no evidence at all. First up, next para. Under similar circumstances, it is contended that when certain documents were sought to be relied in connection with a different land acquisition case by one of the parties, the coordinate bench of this court had remanded the matter and directed the parties to adduce evidence. Full stop. Such unreported judgment dated April 13, 2023, passed in FA 47 of 2005, recorded that it appeared that the documents relied upon by both the parties were marked as exhibits upon dispensing formal proof thereof. Full stop. The parties did not adduce any evidence. Full stop. Under such circumstances, the division bench observed that it felt that the matter was required to be heard on evidence and accordingly set aside the impugned judgment and directed the learned trial judge to hear the matter afresh, granting the parties liberty to adduce evidence, both oral and documentary, in the form of affidavit of evidence by both the parties. Full stop. Next para. Learned counsel for the state also relies on a judgment of the Supreme Court in the matter of Sanjay Kumar Singh versus State of Jharkhand, reported at 2022 within bracket 2 Indian Civil Cases 746 within bracket SC, in support of the proposition that allowing application filed under Order 41 Rule 27 of the Code of Civil Procedure does not lead to result that additional documents / additional evidence can be straightaway exhibited, rather, applicants would have to not only prove existence, authenticity and genuineness of said documents, but also contents thereof, in accordance with law. Full stop. It is submitted by the state that in the present case, the referring claimants, being the respondents, have filed applications under Order 41 Rule 27 of the Code of Civil Procedure thereby seeking to produce as additional evidence the certified copies relied on by the learned trial judge, full stop, even if such documents are permitted to be adduced as additional evidence, comma, it is submitted by the state that the matter has to be remanded to the trial court and formal evidence has to be laid to prove the said documents. Full stop. Next para. Learned counsel appearing for the referring claimant submits that the respondents have preferred separate applications under Order 41 Rule 27 of the Code of Civil Procedure for abundant caution, comma, seeking to produce the said certified copies. Full stop. However, comma, at the same time, comma, it is pointed out that certified copies of the judgments in question were produced in connection with one of the matters in the code below, and since the matters were heard analogously, comma, such production sufficed for the purpose of the court to deal with the said documents and rely on the same. Full stop. Next para. It is further reiterated that since all the proceedings appear arise out of the self-same acquisition procedure as well as same notification, comma, the judgments governing the previous compensation cases, comma, which was at the instance of a company, comma, which was also one of the referring claimants, comma, should govern the present case as well. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that in the present case, comma, the learned trial judge placed reliance on certain judgments. Full stop. It was recorded by the learned trial judge that all the referring claimants in the instant cases filed judgments passed by this court dated November 18, 2016 in LR Appeal number 18 of 2002 within bracket V, comma, which was passed by this court against an appeal in FA 65 of 2014 filed by the judgment debtor stroke state, as well as cross appeals filed by the referring claimant. Full stop. Next para. The court further recorded that being aggrieved by the judgment passed by this court, comma, the judgment debtor state had preferred an appeal before the Supreme Court, which was ultimately dismissed by the Supreme Court. And as such, the judgment delivered by the High Court attained finality. Full stop. It was further recorded by the learned trial judge that the said judgment passed by this court and finally affirmed by the Supreme Court was in respect of the self-same notification, comma, the same project, comma, the same MOSA, as well as the same award involved in collector's case number LA Roman II stroke 50 of 1988-89. Full stop. Next para. Having recorded so, comma, the learned trial judge referred to the certified copies of the said judgment. Full stop. In the judgment passed by the High Court in FA 65 of 2014, comma, which arose out of the self-same notification and acquisition process, comma, the court clearly delineated the parameters on which the valuation was to be assessed and also passed necessary directions to the following effect. Eight na page 116 থেকে sorry page 114 যেটা দাগ দিলাম এই বোল্ড লেটারে একটুখানি ইয়ে করে দেব। Next para. In such circumstances, comma, the learned trial judge relied on the judgment of this court passed in FA 65 of 2014, comma, which was affirmed by the Supreme Court with an order dated December 13, 2017, where the Supreme Court came to the conclusion that no ground of interference is made out in exercise of its jurisdiction under Article 136 of the Constitution of India, and accordingly dismissed the special leave petition filed against the judgment of this court. Push up next para. The state now alleges that in view of the certified copies of this court and the Supreme Court having not been formally proved, comma, the learned trial judge acted without jurisdiction in relying on the same. Full stop. Next para. However, comma, it is well settled that procedure is the handmaid of justice. Full stop. The courts have to distinguish between certain procedural norms which are set in stone and cannot be deviated from, comma, since those hit at the root of the matter, from those which are, comma, although procedural in nature, comma, directory in their form and in their content. Full stop. Next para. Certified copies of public documents under Section 63 of the Indian Evidence Act 1872 include certified copies given under the provisions thereinafter contained.
Section 13 of the Evidence Act, judgment.
Thank you. Push up. Next para. Section 65 of the said Act enumerates cases in which secondary evidence relating to documents may be given. Full stop. Next para. As rightly pointed out by learned counsel for the state, comma, Section 13.
Possibly. 1 3 minor possibly.
No.
Certified copy of the judgment. Evidence sector.
42 is relevancy of effect of judgments orders other than those mentioned in 41. 41 is relevancy. 42 is there.
Public document 76. Certified copy.
No, 42. Section 42 also is there.
Yes.
As rightly pointed out. Furthermore, comma, Section 42 of the Evidence Act provides that judgments, comma, orders or decrees other than those mentioned in Section 41 are relevant if they relate to matters of a public nature relevant to the inquiry, semicolon. However, comma, such judgments, comma, orders or decrees are not conclusive proof of that which they state. Full stop. Next para. In the present case, comma, the question is as to whether the judgment passed by the High Court on the previous occasion in connection with the self-same notification and acquisition process was relevant or not. Full stop. Since the said judgment not only relate to matters of public nature, but is also directly relevant to the present inquiry, comma, we are of the opinion that the production of the certified copies of the said judgments was sufficient compliance of the provisions of the Evidence Act for the trial court to look into such certified copies. Full stop. Next para. It is right law that if several matters are taken up analogously, comma, and evidence is also adduced in a composite manner, comma, the production of evidence in a particular in one of those matters tantamounts to production of the same in all the matters. Push up. Next para. Thus, comma, the rigors of the ratio laid down in Sanjay Kumar Singh Supra are not applicable in the present case. Full stop. In fact, comma, we hereby find that the applications filed by the respective respondents in the present appeals under Order 41 Rule 27 of the Code of Civil Procedure are redundant, comma, since the certified copies of the relevant judgments were already before the learned trial judge when the learned trial judge passed the impugned judgments and decrees. Full stop. Thus, comma, there is no further necessity to permit production of the self-same certified copies by way of additional evidence in the present appeal. Full stop. Next para. Insofar as the unreported coordinated bench judgment cited by learned counsel for the state is concerned, comma, in the said matter, comma, it is not recorded anywhere that certified copies of judgments comprised of the evidence which was produced in those cases. Full stop. Rather, comma, it transpires that the relevant documents pertain to the merits of the case, comma, being comparable instruments and sale deeds. Full stop. Next para. Thus, comma, the facts of the said case are diametrically opposite to the present case. Full stop. In the event sale deeds were sought to be produced for the first time before this court or not exhibited in the trial court, comma, it would undoubtedly provide an occasion for this court to consider whether those deeds would be directed to be produced as additional evidence, comma, in which case we would look at a remand scenario. Full stop. However, comma, as opposed to the same, comma, all the material adjudications had already been made by this court in FA number 65 of 2014 in respect of the self-same notification and acquisition process. Full stop. What remained was for the learned trial judge to look into the certified copies of the said judgment, comma, which was affirmed up to the Supreme Court, comma, and merely to reproduce the salient features of the same in its judgment. Full stop. Next para. The learned trial judge precisely did the same, and as such, comma, we do not find any occasion to interfere with the same. Full stop. Accordingly, if it subcode FAT number দিয়ে such and such are dismissed on contest without any order as to cost. Full stop. Consequentially, comma, the connected applications bearing ওই কোনটায় কি ক্যান নাম্বার ক্যান 6 7 নিয়ে বলে ব্র্যাকেটে ইন এফএ নাম্বার বলে প্রত্যেকটা দিবেন stand disposed of as well. Full stop. The deposits made by the state stroke appellant in connection with each of the appeals with the learned registrar general, comma, along with interest accrued thereon shall be disbursed in favor of the respective respondents in each of the appeals as and when approached, comma, after deduction of the statutory dues. Full stop. Next para. In the event, comma, even after such disbursal, comma, there is still some balance awarded amount which remains unpaid, comma, it will be open to the respondents claimants to levy execution in the court below in order to realize such amount.
Well, they are already execution filed.
In the pending execution.
Levy execution, যেখানে বলে
Adjustment will
liberty
be
to
made.
levy execution and or proceed with the existing execution cases, comma, if pending.
Yes.
বলে বাকিটা যায়।
But in the execution case, adjustment will be made.
Suddenly, why?
For the balance only.
One line.
We have said for the balance, there.
Balance adjustment, the executing court will decide.
Suddenly, it is automatic.
We have said they will be at liberty to proceed with the execution case for the balance amount.
You also kindly record it balance amount.
We have recorded there.
And then the
balance এর জন্যই execution করতে পারবে। Yes, thank you.
Formal degree required to be declared.
Yes, thank you very much. He is correct. A formal degree be drawn up accordingly. Thank you.
Paper
For the respondent. Yes.
but the
Paper book, we directed
there is
without
no
paper
paper
book.
because already filed an application for stay. There are when the matter appear before lawsuit, you also be well hear the matter. But the custody of the child, my lord.
Settlement failed.
No,
Obviously.
settlement failed. Settlement failed. The order was passed in the year 2019. Now the age of the son, second son, the minor son, he is 15. And initially he was with the custody of the father.
No, when did you direct the appeal to be heard? On 4th of December.
Yes.
Let us just check it.
Paper who have not prepared, but there's no direction also.
Deemed to be admitted, request on counterpart that the matter.
2024. But there's a direction for paper book. I think the admitted to be listed for hearing.
The matter relates to custody. Yeah, you are the father. Can it be done on the papers already on record, Mr. Bandyopadhyay?
Other document,
or should we direct an informal paper book?
I can
do that. We'll do that. We can. So prepare informal paper books, Mr. Bhattacharya. You can file it in court. We'll fix a date whenever it suits both of you, and give a copy to them in advance. So
But I am also there.
Oh, Mr.
But I am also there.
No, you're. We don't see you. He's leading you.
Yes.
He's leading you.
I didn't see him. That is why.
No. How soon can you prepare paper books, Mr. Basu and Mr. Bhattacharya?
My lord, it is in the case, my lord, is a judicial officer is involved.
Yes.
I request your lordship to do something, my lord, to resolve the problem.
Just because one of them is judicial officer, we cannot. He or she is the
Not
father
on
of the
that,
mother.
otherwise also, if a lordship kindly do something
child
for
in question.
What can we do? We can send it to
The
mediation.
child in question will appear for boards. He's almost 16. The matter will be resolved within a few years.
Child was in Jalpaiguri. The mother transferred to Andaman. Now he has been transferred to Alipur.
Discussions are not
It's
necessary.
Alipur. Yes, he has been transferred.
How will that help in custody?
We don't know.
Two
that.
sons.
I also don't understand.
Whether she's
Two
in
sons.
Andaman or in Birbhum or in
The
Alipur.
first son is already staying with the
Mr. Bandyopadhyay, is there any chance of mediation in this?
Perhaps.
I request Mr. Bandyopadhyay to do something.
Mr. Basu had started the discussion with me, but there has been thereafter a pause of 3-4 months. Mr. Basu never pursued it, and I am sure because his client never pursued Mr. Basu for that.
No, this is not correct. It is my fault. I could not contact you. It's my fault.
Did you refer it to
Please, Mr.
mediation?
Bandyopadhyay, kindly do something.
It was referred.
It was referred to mediation.
Earlier, it was referred at the stage of section 24. In the
But
section
his
20.
client won. His client did not attend.
It's not about about finding fault. Both parties have to agree to a mediation.
Mr. Basu, now I recollect. Probably the lady, she is a judicial officer. Still recently, she was a judicial officer of Andaman.
Yes.
I was in that zone. I've seen the son also and the lady. So I think we should really.
But now she is not in Andaman. Now she.
I recollect her. I have seen her and her son also. More importantly, the son.
Yes.
More than the lady, the son.
But Malad sees the papers. Malad
will direct you to prepare paper books, but I think I should release them.
Kindly don't release it.
Kindly don't release it formally.
Not that I'll be biased. I don't.
May I say this, Malad? My client will always remain a judicial officer. My learned friend's client will always remain an advocate. Or whichever court we go, Malad, there will be
the child. I have seen the child. I know the child. Because there is a formal dinner held when we go there.
Oh, yes.
The zonal judge goes there, a formal dinner is held.
All of your lordship goes to Andaman or sometime.
Every honorable judge will be there.
Zonal judge of some district.
Not that. If I did not, the child is known to me. Also.
Oh, yes, that
Son, I know. I have.
Malad, kindly not. Malad, if I may say this, kindly not release it right now. Malad, let the paper books be filed. Let us come back in June. If your lordship feel that your lordship will release it, kindly release it.
Or we are still there then.
Oh, that you have
Malad,
that is why, Malad.
No, we are not releasing.
In the
Then it will
meantime,
be
let us,
difficult to get
let us,
One release order means, Malad, my learned friend will have to ask for an
enlistment and yes, very good. We'll
in the
directly-
meantime, let us again
Maybe by
explore,
June, your
explore.
lordship will forget about the son. That your lordship met him.
Who will forget?
So how soon
It's
can
not
it-
possible. This is not possible.
So
Let us
you
again explore the possibility.
Prepare,
Let
Mr.
us
Basu,
explore.
prepare your paper books within
Yes,
before
and
the
let us
closing.
explore. Don't release it. Don't release it.
We are not releasing.
No.
We find from the documents involved that preparation of informal paper books would be necessary for hearing the appeal comprehensively. First, accordingly, the appellant is directed to prepare informal paper books without comparing with the records by May 20, 2025. May 20, 2025, full stop. Advance copies of the same shall be served on the learned advocate appearing for the respondent. Full stop. The matter be placed for hearing in the monthly list of June 2025. The appeal be placed in the list for hearing in the monthly list of June 2025 along with the connected application.
Let it be there for the time being. Let us explore the possibility.
একটা লাইন অ্যাড করে দিন তো pendency of the matter pendency of the matter shall not prevent the parties from exploring mutual reconciliation in the matter.
Grateful, I'm grateful.
Unless there is a clear direction from it, because I
There
went.
cannot be any direction for reconciliation. We cannot direct parties to reconcile.
And divorce is also pending.
Obviously. এটা কাল ভাঙা কাল ভাঙা যেটা আপনার মতো আপনার ছিল
এটা ছিল
ও
আসলে অর্ডার করে
After checking up that the appellant is not there, you have come. When the appellant is there, you don't come.
Well, I have come up with a
What is
letter
the-
also. My lord, this is a matrimonial. Good, my lord, I am for the respondent husband. I was the plaintiff before the trial court. Degree was granted in my favor on the ground of cruelty and desertion. But my lord, and there was the matter was admitted, and subsequently it was sent for mediation also.
You're there.
My lord, I appear for the petition, my lord. My lord, I am praying for not today, any day next week, my lord. Next Friday.
Why you are there? You're always ready in matters.
My lord, my senior, Mr. Roy, is not here today. I am ready with the matter, but not today, my lord. Next Thursday.
Well, on the prayer of the appellant, let the matter stand adjourned till May 8, 2025. Next Thursday, any difficulty, Mr.
No, my lord, I have no difficulty, my lord. All these appeals, my lord, I heard out, my lord. My lord knows that.
Is pending, yes, my lord.
Yes, yes, exactly. These appeals are pending for so long.
Matrimonial appeal will not take much time. That's all.
That we don't know. May take time also. But
I
should
think
be disposed of
yes,
expeditiously.
no, my lord, because
Matrimonial appeals definitely should be disposed of. People are waiting for so long.
yes, my lord.
My lord.
Yes.
27, my lord.
My lord,
I am for the respondent. My lord, state has preferred an appeal.
my lord,
As also,
I
I
am
have
for the-
filed a cross
objection. We have said.
objection.
Yes.
My lord, I am for the state appellant, learned advocate for the state. Mr. Suman Sen Gupta is unwell and has not been able to come to the court today.
He has not come to court.
No.
You are sure? If you see him in some other matter, we'll call for you.
I am seeking an accommodation for this work. 27. I am
Yes.
seeking an accommodation for this
On the
week.
prayer of the state, comma, let the matter stand adjourned for the day, means next week.
My lord, maybe for this week.
Not today means not this week, because tomorrow we sit singly.
Next Thursday.
No, Monday it will be in the list, but probably we won't be able to reach so much.
Grateful, my lord.
Please give the appearance, sir. Please give your appearance. 29 you are for the appellant?
I am for that.
Yes. What is the matter?
Lordship, my submission very short, Lordship.
What is that? Dismiss the appeal. This is also land acquisition.
This is also land acquisition.
Yes. What is your submission?
Lordship, the dispute arises regarding the decretal amount. Actual date of position was taken on 27th December 30th March 2009 instead of 27th December 1989. So recurring compensation did not pay from
Possession was taken on 30th of March 2009. What happened on 27th December?
27th December 1990, the decretal amount was in the judgment decree passed on the 27th. Position was taken. Position was taken on 30th March 2009 instead of 27th December 1989.
Who said 1989? 27? The court has held 27th December night.
So recurring compensation did not pay from 27th December 1989 due to position was taken on 30th March 2009.
So therefore, the judgment should be modified to that effect.
Lordship, kindly see the annexure R2 of my affidavit of opposition.
Affidavit in opposition, paper books are now ready.
The
What affidavit?
Calcutta Gazette, the position was published.
Was it a part of the trial court records?
Lordship, the Lordship has division bench order to submit the Honorable Division Bench direction to submit a affidavit of opposition on behalf of the appellant.
Affidavit in opposition to what?
The calculation.
Regarding
Affidavit in opposition or affidavit?
Lordship, my submission is published. The notice was published on Tuesday, November 11, 2008. Regarding and as per Land Acquisition Section 11, inquiry and award were collected on the day so fixed or on any other day to which the inquiry has been adjourned. The collector shall proceed to inquire into the objection, if any, which any person interested has stated person such and such, and into the value of the land at the date of the publication of the notification under section 4, subsection 1, and to the respective interest to the person claiming the compensation and shall make an award under such and such. So, Lordship, the published on November 20, 2008, and land
November 20 or November 11?
November 11, 2008.
Yes.
And
Notification was published on November 11, 2008. Land, the possession was taken on 30th of March 2009. And trial court wrongly recorded that it was 27th December 1989.
That is my submission.
So why do you say wrongly? What proof is there to show the date of possession?
Date of position.
What evidence was led by you to show that the date of possession was that? Why did on what basis did the trial court hold so?
We have submitted the.
Let us see the basis why. Yes.
Trial court, an application was submitted before.
Trial court has not recorded all these. This is absolutely a new fact altogether.
And Lordship, the land.
Where do you get that it was the date was 30th of March?
Land is taken on 30th March 2009.
What is this you are handing over? Daran.
Certificate of possession of land made over the parties on whose it has.
Was this produced before the trial court? How can we look into it?
Nothing.
But submission was made on the before the trial court. And trial court has rejected the such.
Was this a part of the evidence before the trial court? Did you adduce this as evidence? Did the state adduce?
State has submitted a prayer before the trial court.
Prayer?
After the
under which provision of law? After
the judgment was passed.
After the judgment was passed, can the court look into any document after the judgment is passed? Why we won't take it into consideration?
Lordship, that fourth ADG Alipur.
You are in your own world. We are asking our own questions. We are saying, was this document then therefore was not a part? You did not adduce this document as an evidence in the court below. So why how should you look into it? How can we look into it? if it is not a part of the trial court record. Have you filed in order 2141 rule 27 application here? This is basic law. Very basic law. Can the appeal court look into a new document if it was not before the trial court?
Appeal court 2 days fees for clerks and parties to no steps.
What is there in order 41 rule 27?
220. Lordship, this,
Order 41 rule 27, what is it?
Lordship, the trial court has rejected my.
No, what is order 41 rule 27 according to you? What is there in order 41 rule 27?
No.
You don't know?
No. Lordship. Only we have prayer before the trial court, 4th AD Jalipur, my prayer was rejected.
What is order 41 rule 27?
47 is they have not filed 57.
If you filed, what would be your prayer?
My prayer only to kindly
please come
date of
prepared.
question might only from 30th March 2009.
But then we won't adjourn. So this document below, nothing. What was the basis of holding that this is the date of possession?
This is first time I'm hearing all this.
No. What is the basis? The court must have some basis. Court had found, we are seeing the judgment, impugned judgment.
Yes.
There the court is saying that date of possession is such and such. What is
Squatters were there from that date in my land.
How does the court get it? In your
It's-
pleadings? In their pleadings? Let us see.
Kindly come to the
Must be in your pleadings.
claim application.
Yes, let us come there. Some records must have been there.
Page 13 is the claim applications.
Yes. What is the basis of the court getting this? That is what we are asking.
Even
Must be the records. DLA records থেকে পেয়েছে নিশ্চয়ই। PW1 এসছে, certified copy of deed দিয়েছে, confession। Stated কি অবস্থা হলো? Take it apart for two. And your cross objection is regarding what? You have filed a cross objection?
no, not in this matter.
Nothing.
In the previous matter.
No refusal here. Yes, we'll continue after the recess. Think about your grounds. ছোট কিছু 30-40 কিছু বলছি 28-12 নিয়েছে সেটাও বোঝা যাচ্ছে
Well, I checked up the LCR on lower court records, and from the lower court records, I could see that my learned advocate who was appearing before the court below has given a synopsis and provided before the court, and that was countersigned by the learned GP who was appearing on behalf of the state in the court below, as also the rate report which was relied by the collector while passing the award. The collector has mentioned the name and scheme for which the acquisition had taken place, Jodhpur Park, K site, and in that rate report, the other property possession was taken in the year 1982. And in respect of my property, well, in that synopsis, it's been written that 1989. Thereafter, learned GP received the copy, never objected to that. Subsequently, passing of this order, well, they came up with the review application that was turned down.
Review before that court.
Before that court.
On this ground.
On this ground, that order has not been challenged by the state.
Those are all part of the trial court records.
Yes.
Review order is also there.
Yes.
Yes, what do you say?
Nothing to say. Let's see.
It is very difficult to fight these cases for the state. We can appreciate that. We are seeing so many matters. Here you cannot improve the case. That is a difficulty. And this is public money. The state ought to be more careful in the courts below. We feel for you because you have a daunting task here.
Filed a review application before the district judge.
Review also rejected.
The state application.
That has not been challenged.
So then we have to close this appeal.
No evidence has been adduced by them.
Because the primary ground is the date of possession.
After officer, there is no exhibit in the judgment.
No evidence was adduced. How can they be exhibit? How can you? I mean, we know what is the situation for you. You had adduced evidence.
Yes.
স্টেটের দেখছেন সবকটা একরকম এখানে সে বাচ্চা যেটা বলছিলেন না
ওটাই তো
এখানে কি করবে
there were squatters to regularize them. State got the property acquired and subsequently gave them patta. That's how the date of possession is 82/1989.
This is which court?
Alipur.
Only my submission notification was made on 28 November 11, 2008.
We are dismissing the appeal. We are recording. Learned counsel for the appellant submits, appellant stroke state submits that the notification in respect of the award which was passed by the LA collector, giving rise to the reference under section 18 of the Land Acquisition Act, was published on November 11, 2008, full stop. It is argued that although it was recorded by the learned trial judge that the date of taking possession was December 27, 1989, possession was actually taken on March 30, 2009. Full stop. Although learned counsel for the state seeks to rely on certain documents in that regard, we find that no application under Order 41 Rule 27 of the Code of Civil Procedure has been filed by the state, and as such, such proposed documents not being before the learned trial judge at the time of passing of the impugned judgment, nor any application having been made for production of additional evidence, we are unable to look into such documents. Full stop. Next para. Learned counsel for the referring claimant stroke respondent submits that in the trial court, a synopsis was made and filed by the learned advocate appearing for the referring claimant, giving the necessary particulars, which was received by the government pleader, who appeared for the state in the court below, and countersigned by the said government pleader. Full stop. Next para. The impugned judgment, it is submitted, was passed on the basis of the said synopsis, as well as the rate report authored by the collector, which also gave the name and scheme of the purpose of acquisition as well as the necessary details. For next para, more importantly, learned counsel for the referring claimant submits that a review application was filed by the state in the trial court in respect of the impugned judgment, which was rejected and has attained finality, in the absence of any challenge thereto. Next para. Under such circumstances, it is submitted that there is no infirmity in the impugned judgment, and as such, the appeal should be dismissed. Next para. Upon going through the materials on record as well as the trial court records, we find justification in the contention of the respondent. We also find that the state did not adduce any evidence in the court below, whereas the referring claimant had deposed in support of their case. Next para. Since the learned trial judge acted on the said evidence which was before it and the undisputed documents, we are of the opinion that there is no scope of interference in the present appeal. Accordingly, FAT 96 of 2021 is dismissed on contest without an order as to cost. A formal decree be drawn up accordingly. Sorry. Yes.
And money they have deposited.
They have deposited, right. Article line at Koda. The respondent, the learned registrar general shall disburse the amount deposited by the state appellant with the learned registrar general in connection with the appeal in favor of the referring claimants, as and when so approached, along with the interest accrued on the same, after deducting the necessary statutory deductions. In the event the said amount does not meet the entire awarded amount, it will be open to the referring claimant stroke respondents to levy execution stroke proceed with execution for recovery of the balance amount.
I'm deeply aware.
Thank you. Judgment. Formal degree be done up.
My lord, item number 10 and 11, the written notes, may I file it
Yes,
in court? I'm deeply obliged.
ওটা ওর মধ্যে ঢুকিয়ে পাঠিয়ে দেবে আর ওই পল্লবকে কিন্তু বলে দেবেন ওই দুটো বই দিতে
May please your lordship, I am appearing for the appeal.
You for the response.
And the appellant is the petitioner before the learned additional district judge Paschim Midnapur. He filed a suit for divorce under section 13(1) of the Hindu marriage. Lordship, kindly come to the.
Can you please take the microphone a bit closer to you?
Lordship, kindly come to the order passed by the learned additional district judge Paschim Midnapur at page 44 of the paper.
The ground was cruelty or desertion?
Cruelty and desertion both.
Both.
Lordship, kindly come to the page 44.
44,
relevant page, Lordship. Relevant page 47. Paragraph number 3.
47.
Relevant page 40.
Judgment starts from page 19 in your paper book.
Here from page.
No, my lord, the paper book second time was filed.
There is a supplementary paper book.
Supplementary paper book, part 1 and part 2.
Achha. So we'll look into the supplementary affidavit.
A supplementary affidavit. It has become a complete.
Achha.
Complete paper.
Yes.
Kindly come to the page
44 relevant pages. Sorry, page.
Relevant page 47.
47.
Page 47.
Yes. You please take your seat. Yes. Yes. 47.
Page 47, my lord. My lord,
what else some lady did not give you a cup of tea?
Not only
times
that,
have changed, sir.
Not only that.
Yes.
Kindly see, my lord. The petitioner has filed in the year 2006 a suit for judicial separation under section 10 of the Hindu Marriage Act. And in that judicial separation suit, she appeared, but she does not contest. And the judicial separation, kindly come to the page 26. This is, my lord, supporting documents of the evidences laid by the husband, my lord. My lord, page 28 is the order passed by the learned district judge.
Oh, that was decreed expert.
That was decreed expert. My lord, since 2006, there was no, my lord, spouse living, and she is separated living from her husband. Lordship, kindly come to the, my lord, plaint petition filed by the husband.
When was this suit filed? Present suit?
This suit was filed in the year 2015. 2015.
All right.
My lord, kindly come to the relevant, kindly come to the plaint petition of the, my lord, filed by the husband.
Yes.
My lord, relevant paragraph is, my lord, marriage was performed, kindly come to the paragraph number 1. Marriage was performed on 30 January 1996.
Right.
My lord, kindly come to the relevant paragraph, my lord. Paragraph number 5, page 3 of the paper.
Yes.
Lord, this is the averment made by the petitioner husband that it is a matter of regret that the respondent did not allow the petitioner to enter into his rented house. While once he had come to her matrimonial house, and there she was not agreed to live with the matrimonial house. Thereafter, my lord, the petitioner husband took a rented house at his service place. The petitioner is an engineer, and my lord, he is servicing at Kharagpur, diesel shop, and at his service place, my lord, he took a rental house, and in that rental house, my lord, she used to live there. Kindly come to the paragraph number 5, which I am reading. This is that it is a matter of regret, great regret, that the respondent did not allow the petitioner to enter in his rented house at Malunjo since May 2004. The petitioner could not speak about all this to any other person for the sake of prestige of family. The petitioner's life has become miserable due to the cruelty of the respondent for a long time. The petitioner paid the house rent along with the house expenses for the respondent. Even then, the respondent did not allow the petitioner to enter in the house. The petitioner is staying in a mess at Kharagpur for the time being. Next, paragraph 6. The petitioner have tried his level best, even with the help of the well-wishers, to live with the respondent as a husband and wife, to lead a happy conjugal life, but in vain. In such circumstances, it was impossible on the part of the petitioner to live together as husband and wife. Paragraph number 7, my lord, that the petitioner for such cruel treatment of the respondent filed mat suit number 610 of 2004 before your honor's court against the respondent for judicial separation under section 10 of the HM Act, and the said suit was ultimately decreed on 21/11/2006, passed by the Transferee Court, Additional District Judge is Court, Midnapur. My lord, after passing of the judicial separation decree, the wife, my lord, respondent has never come before the, my lord, court for reconciliations of their marriage.
Court proceeded on the premise that she resided in your matrimonial home.
Yes.
Therefore,
my lord,
there was no desertion.
The respondent, according to my lord, the plaint, my lord, it was mistakenly written in the cause title that she is residing in matrimonial home. That address was given. Address was given.
Take your seat.
That address was given. But kindly see, that address was given. And even if, my lord, that address was given,
No,
if
even
there
if
is
she
no,
was
my lord,
residing
spouse living,
even if she was residing in the matrimonial home,
yes,
you are residing elsewhere. So you can very well argue that she did not live with you.
Yes, my lord, according to, my lord,
Because the law says that she has to return to you. She has to live with you, not at her matrimonial. You are not residing in that so-called matrimonial home. You are residing
No,
somewhere
no.
else.
At the initial stage, my lord,
Initial
they
stage, forget.
used to decide that. And thereafter, my
last
lord,
decide
at that, my lord, at her instigation.
Not that we are speaking in your favor. You say that initially you are residing in the matrimonial home.
Yes.
There was a marriage, their son was born, obviously.
Yes.
Son is now an adult. Now thereafter you shifted to please.
Shifted to the rented house.
Shifted to Kharagpur and then to Bhawanipur and to Malanchu. That is your
Malanchu. Yes.
Bhawanipur, then Malanchu.
Malanchu.
You say that she did not reside with you there.
Yes.
She did not let you enter there. That you
Yes.
said. So she resided where? At Malanchu then?
At Malanchu then.
And you are residing where?
Went back to residing in a mess.
Kharagpur.
Kharagpur. Malanchu is in Kharagpur. Malanchu is in also Kharagpur.
So, but she did not return to you.
Yes. Then my lord kindly come to why she did not return. My lord, she used the defamatory. My lord, kindly come to her written statement.
Yes, written statement.
Well, it is crystal clear from the detailed statement that she did not never serve the husband and always she was engaged with the ill child. Kindly see that. Well, first paragraph number 2.
It is your child also.
It is my child also.
If the wife looks after the child, she does not look after you. What are you, a Nawab or something?
No, that is not.
Then?
Kindly see what
she looks after your child. She cannot look after you, cannot make a cup of tea and all these allegations.
No,
kindly. You are sort of a, I mean, a
kindly see.
King or something like that. Peculiar allegations are, because of your allegations, probably you won't get a degree. Otherwise, you would have a good case. She did not come back to you. You have a degree of judicial separation.
He did not come.
That itself is a ground. If after judicial separation, she does not come back.
She does not come back. She does not come back. My lord, the separation is more than, my lord, 19 years. There is no chance of reconciliation of spouse living. My lord, marriage had, my lord, broken. Marriage has become dead. It's a irretrievable marriage, my lord. Therefore, my lord, I am relying upon the judgment of Samar Ghosh. And
after Samar Ghosh, there is a judgment of Justice Sudhanshu Dhulia. We forgot that, where this has been included as a ground. Irretrievable breakdown has been included as a ground. Unlike the other cases, Samar Ghosh, failure to perform matrimonial duties, that itself is irretrievable breakdown. But anyway, rely on those judgments.
First of, my lord, kindly see that I am relying upon the judgment.
Yes.
When the defamatory allegation by the wife in her pleadings.
What is the defamatory allegation in her?
Defamatory allegation, my lord, I am showing.
Show us the defamatory allegation.
Defamatory in her pleadings, I am showing that. Paragraph number, my lord, 9.
Illicit relationship.
Yes. My lord, this is only the cause, and this is false allegation against the husband.
She did not prove it. Illicit
it is not proved by your evidences. Kindly see. This is the defamatory. My lord, it is
yes.
Defamatory, my lord, kindly paragraph number D. Paragraph number 9, paragraph C.
Of what? The Samar Ghosh judgment? Or your written statement?
In my paper book, paragraph number D. Paper book, page 10, page 4. A written statement, page 4, page 10. Page 10. That in the year 2003, the petitioner indulged is an illegal relationship with one widower, namely Monisha Bose, who also worked as female khalasi in the diesel shop POH shop, Kharagpur, Indian Railways, and started living together at quarter number L61. There is no any kind of evidences laid by her before the dock of the court. Even no single document is produced.
Contested the suit till the end.
Yes.
Did not adduce evidence at all.
Did not adduce evidence at all. No.
She did
regarding
not
this.
Regarding this, she did not depose.
Yes.
But she otherwise adduced evidence.
Yes.
But regarding this,
regarding
relations, there was no evidence.
There is no evidence. as female Khalasi in the diesel shop, Kharagpur Indian Railways, and started living together at quarter number, etc. New settlement, Kharagpur Railway quarter, Kharagpur, Paschim Medinipur, West Bengal. Hello, bringing this allegation, she refused to live with her husband. Bringing this allegation only, nothing but. This allegation, bringing this allegation. All along, my lord, husband tried his level best to bring the wife to him, to his place, but she refused. She refused. And my lord, all along, my lord, he bear all the expenses regarding the medicines and medical expenses of the child. In the long run, the child was dead. And that is not the fault on the part of the husband. Because there is no cooperation in between the husband and wife, my lord. There was no spouse living long, about 19 years.
Child was saved from much ignominy probably by his death.
My child, from the date of the birth, my lord, child was suffering from the muscle contraction.
Yes, we have seen it. Muscle
contraction.
atrophy probably.
And my lord, after that, my lord, the husband, being the petitioner and father of the child, my lord, used to take every steps, my lord, to attend every hospitals, visited doctors. And all the prescriptions are in the custody of the husband. And there was no evidence regarding that all the medicines, all the prescriptions of the doctors, all the, my lord, time the husband visited the hospitals.
Have you argued before the trial court regarding this illicit relationship allegation? We don't find any argument here.
Yes, my lord,
If
that
you
is,
argue-
my lord, kindly see only that is the paragraph number, that is page 47.
Mhm.
There is no whisper. Paragraph number 47 and only paragraph, kindly see page 48 of the paper book. This is only the observation, paragraph number 3. This is only the observation. Kindly see. This is only the observation to refuse his prayer for divorce. This is, I am my lord reading. Though it was not pleaded and the plea did not appear in the four corner of the suit that the petitioner prays for dissolution of marriage on the ground that there was no cohabitation. My lord, there was no cohabitation. And it is clear affirmance from the plaintiff also that there was no spouse living with the husband and wife. So if there was no, my lord, spouse living with the husband and wife, now how can the, my lord, learned judge say that there was no cohabitation? They are separate living.
But in your cause title of the plaintiff, you have given the same address.
Yes, that is, my lord, mistaken on the part of the, my lord.
You never corrected the mistake. That remains till date.
It was mistaken.
And if she was served at this
But
address,
my lord,
the
on that,
notice of the appeal must have been served at that address, and she is appearing.
On that point, my lord, I am relying also judgment upon the judge.
First, you finish this Samarkos judgment. Which paragraph you are relying on? Let us go one by one.
My lord, kindly see the Hindu Marriage Act 1955, section 13(1)(a). Mental cruelty, instances of wife's indifference. Second page. Wife indifference and neglect of husband during his illness. Wife humiliation of husband in front of her father and his servant, who virtually telling him to get out of the matrimonial home. হ্যাঁ হেডিং টাই প্যারাগ্রাফ
Come to page 547. Para 101, Roman 14. That is your case.
101. Roman. 101. Yes, where there has been a long period of continuous separation, it may fairly grateful to it may fairly be concluded that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by a legal tie. By refusing to sever that tie, the law in such cases does not serve the sanctity of marriage. On the contrary, it shows scant regard for the feelings and emotions of the parties. In such like situation, it may lead to mental cruelty.
In your evidence, have you stated that you are living somewhere else? In your evidence, in the suit, let us see that. Because in the cause title, we find that, or in your pleading, in your pleading you have stated. Because in your pleading you have stated that you are living elsewhere.
Yes, elsewhere. W1.
Let us see your evidence where you have stated that.
Yes, affidavit in chief.
Page 21, you have stated, I am staying in a mess at Kharagpur for the
Yes.
time. For the time being, you have said.
For the time being, affidavit in chief. Page 21.
Yes. Page 20, you have also stated that same thing you have repeated, whatever you said in your plaint. I took a rented house at Kharagpur and such and such. Did not stay. But you have said my wife did not stay in the said place continuously. But your judicial separation suit was after that.
After judicial separation, my lord, there was no married spouse living in between the husband and wife.
Where have you stated that? That is also one of the premises of the court.
My lord, in the affidavit in chief, page 21, there is no chance of reunion between me and my wife in any more, as my wife has treated me with cruelty and desertion. I have not condoned the
First two
said
paragraphs of that page also. First two paragraphs also. You are staying in Kharagpur, etc. Could not bring her back and all. Was there any cross-examination on it? Let us see your cross-examination. The son was born obviously before you filed the previous suit.
Yes, son was born before.
Before the previous suit also.
Previous suit. Previous suit.
In her evidence, where is her evidence? Let us see. What did she say? No, she has stated in her evidence also illicit relationship. You said no evidence? Page 31, she has given evidence on that.
No, my lord, there is no evidence by producing any kind of document or by bringing any other witnesses.
What document should she produce? Photographs?
No, not photograph. By bringing any other evidences. There is no any other evidences regarding that fact.
So you say apart from hard evidence, there is no corroboration?
Yes, there is no corroboration.
সিরিয়াস অ্যালিগেশন তো শুধু মুখে বললে তো আর হবে না, আমি তো বলবোই আমি যা বলেছি প্ল্যান্টে। দেখি প্রসিডিংস, দেখি প্রসিডিংস নিশ্চয়ই বলেছে।
And not only that, when the ex parte order was passed
হ্যাঁ বলেছে প্রসিড
regarding my lord judicial separation, she
বলেছে
did not approach before the court, my lord, to set aside.
প্রসিডিং আর কি করবে বলেছে I did not make any complaint against the husband to GP or Thana, not a fact that it is a relation, not a fact that OP has an illicit relationship with OP much. এটা উল্টো হয়ে গেছে বোধহয়, not a fact that OP has illicit relation, দুটো নোট লাগবে, তাও ক্রসে কাউন্টার করেছে। আর তারপরে বলেছে not a fact that OP has relation is a false statement করে, কিন্তু তাহলে ওই ওয়ার্ক প্লেস থেকে কাউকে এনে বা ইয়ে করে প্রমাণ করা উচিত ছিল যে ইলিসিট রিলেশন কর্পোরেট করতে হবে। ইটস সিরিয়াস অ্যালিগেশন, ইটসেলফ ক্রুয়েলটি হয়ে যাবে, আর এভিডেন্সও বলেছে।
My lord, by making this false allegation, she refused to live with the husband. It is a fact. And my lord, this defamatory allegation, and there is no any kind of single witness, eyewitness regarding that. Even not only eyewitness, no any other person also appeared before the court to lead evidences regarding his illicit relationship with that person. But he is an engineer. And my lord, in this society, his name and fame has been also fallen down, lowered down.
Lordship, OPW2
Yes, my
also
lord, very-
stated in his evidence also about the illicit relation.
OPW2 is the father. Is the father. How can he know about the life of the husband and wife for being a father-in-law? It is, my lord, hearsay evidence. After hearing the evidences, hearing his daughter, my lord, he laid evidence. Kindly see the cross-examination of the OPW2. OPW2. And my lord, same version appears. My lord, long separation.
Not only that, page 39 para 8, father says that my daughter came to know that there was an illicit relationship.
Yes.
It's not a direct evidence.
Not direct evidence. Grateful to my lord. Another, my lord, the judgment is Sukhendu Das versus Rita Mukherjee, my lord. 2017 9 SCC. Long continuous separation and refusal to participate.
Cite it. Give the citation and reference.
Here, my lord, it is to participate in divorce proceeding, but long continuous separation.
Give the total full citation for your learned friend so that he can.
(2017) Volume 9, Supreme Court cases, page 632.
This was under Article 142.
Yes.
That is not German here. No, there are better judgments. Justice Dhulia's judgment is their very recent judgment. I forget the citation. The Justice Dhulia has been pleased to hold that his division bench has been pleased to hold that it's cruelty against each other. So reading irretrievable breakdown as cruelty, divorce was granted. But
Judgment.
no, Justice Commission is long back. Justice Sudhanshu Dhule is still a judge of the Supreme. Anyway, so this you are relying on for long period, but this is on 142. This we cannot take into consideration. Court says that it's under 142. Anything else? Any other?
Lordship, kindly allow me some time. I will, my lord, appear.
We won't allow you anything more. We'll just hear him. Yes, take your seat.
Lordship, all along she was residing in her matrimonial house, Lordship.
But the husband was residing elsewhere.
No,
His evidence is there.
Lordship kindly comes to page 33, paragraph 17. He comes he came every weekend. He used to come.
What is that? Which paragraph?
Page 17, Lordship.
Page para 17.
Para 17.
That's your evidence.
Yes. That's why I was living there, Lordship.
This is not you have even in your evidence even you have stated my husband used to come to my matrimonial home weekend day and used to live as husband and wife. But that is not corroborated by anybody.
Lordship, there is that type of
Somebody from
separation.
the neighborhood, anything to show there is nothing to show that he came back to his residence.
And Lordship,
Plus admitted position that he used to reside at the rented house at Kharagpur. That's admitted in
for
your
his-
father's evidence, para 7. Moreover, your illicit relation allegation is not corroborated by any evidence. Somebody from the workplace. The allegation is very serious that itself tantamounts to cruelty. You know that.
Lordship, how can I?
You could have brought somebody from the workplace. Allegations of illicit relationship are in every other matrimonial suit, those can be proved. Some neighbors, somebody from the workplace, anybody and everybody. Some people must be knowing if it's illicit relation of such a stature that you come to know sitting at home, then there must be people from whom you are coming to know. Those people could be adduced in evidence. You are not there, obviously. Illicit relation cannot be direct knowledge. Unless you saw some incident was occurred, you have not stated that. You say there was an illicit relation. You must have known from somebody because you have not alleged that I was there when this happened or that happened. It did not happen at your home. That's not your allegation. There is an illicit relation. You heard from somebody, bring that person on the in the box. Nobody was brought to corroborate. You and your father say. Your father says my daughter came to know there was an illicit, which is more than hearsay.
But Lordship, all along I was staying in my matrimonial.
See, the marriage has broken down irretrievably.
Lordship,
You are residing in the matrimonial home. He is residing in Kharagpur.
But he used to come, Lordship, every weekend.
That is only your statement. Nobody else. If you live in the matrimonial home, you have a good relation with the relatives of the whoever is residing there, his parents or somebody. Because you are living in the matrimonial home, you are saying.
Lordship,
who else lives there? You must have brought them. If you live in the matrimonial home, the home of the husband.
It is admitted because in the cost title of the plaint, it is.
No, you are living at the matrimonial home, that is admitted. We are not saying that it's not that. You are living in the matrimonial home, but you are saying that he used to come there every weekend.
Lordship.
If you are living in the matrimonial home, you must have a very good working relationship with his people who are living there. You are living there regularly with your son. They must be supportive of you, his parents, or whoever he has there. You could have brought even your domestic help could be brought to adduce evidence that he used to come every weekend. Anybody and everybody, whoever is residing there. Nobody from the matrimonial home to say that he used to come there. We proceed on the premise that you were living in the matrimonial home because he did not amend his plaint. But he has stated he resides elsewhere in a rented accommodation.
If he had not any relation, she has not any relation with the husband, why she should live with?
She has a right of residence in the matrimonial home. She does not have anywhere else to reside.
No. She can reside.
This is not unknown that the wife resides in the matrimonial home, husband resides elsewhere. He escapes elsewhere. He is working elsewhere. He is staying there. Just because you live with his parents or in his parental house does not mean you have a right of residence in a matrimonial home. Just because of that, it does not mean that you have a working relationship with your husband. He does not reside there himself.
Rashid, I have stated in paragraph number 17 that
marriage is broken down. There is no use keeping this pending. What are your respective ages now? And there is the bond, only bond between you is gone now. Very unfortunate, but it's gone.
And he did not look after. He also stated in his cross-examination.
But you have stated in your evidence that he used to come in the same paragraph and he used to take him to doctor every weekend. We have seen the evidence because our eyes catch these things fast. We are taking these up all the time. So we have seen in the same paragraph where you stated he came every weekend, you have stated he took him to the doctor. Every weekend, if he comes and takes him to the doctor, you are
Sometimes.
self-demolishing your case.
Sometimes.
You said every weekend. Therefore, you cannot be on a contradictory stand. This illicit relation allegation, there is no corroborative evidence, not a single soul from that workplace. That Kharagpur is a small township. I mean, you could have brought anybody.
That is the fault of the learned lawyer who conducted the.
Have you got your mobile phones with you? Please check up this
2013 SSC online.
2013 হবে
2023.
23. Rakesh Raman's case. Rakesh Raman versus Kavita. Just search that judgment in India Kanun or somewhere. Rakesh Raman versus Kavita. My learned brother is right. That was the name. Justice Julia's judgment. Somewhere in the middle paragraphs. Most probably 2023 SCC online SC 497.
Rakesh Raman.
Yes.
Yes, I've got it.
You have got it. Just check up. Somewhere in the middle paragraphs, it has been stated that if parties do not reside together, it operates as cruelty against each other. Therefore, irretrievable breakdown itself has been taken to constitute cruelty against each other. And in that fashion, his lordship has incorporated that irretrievable breakdown as a ground of cruelty.
Well, Lordship, my case is otherwise.
142, all the other cases are around 142, mostly, except Shamor Ghosh, that stray paragraph. But here, this is a marked change. Rakesh Raman's case, don't know whether this thing is on or not. I'll just check up.
Yes, my lord. They were living separately for 25 years.
And there were no chances to continue in their life.
But in this matter, Lordship, my case is that he used to come regularly.
No, in this case, yes, para 28. In a given case such as the one at hand, where the marital relationship has broken down irretrievably, where there is a long separation and absence of cohabitation, that case it was 25 years, with multiple court cases between the parties, then continuation of such a marriage would only mean giving sanction to cruelty, which each is inflicting on the other. So this is the first time the Supreme Court, without resorting to 142, this is interesting for other purposes also, incorporated this irretrievable breakdown, absence of cohabitation, as a ground, saying that this amounts to cruelty inflicted by each of the spouses against the other. So in that fashion, it was brought within cruelty, and because since 80s, Supreme Court is requesting the Parliament to introduce irretrievable breakdown. That has not been done. In its prudence, Parliament has its own prudence, wisdom, definitely. They are the representatives of the people, so we are not. But this has been incorporated in this fashion. Here, the difficulties, two difficulties. One is illicit relation, no corroborative evidence. Second is that he has been residing elsewhere. There is no evidence to demolish that he has been living in a rented accommodation in Kharagpur, elsewhere than his matrimonial home, but in his parental home. But you are residing in his parental home. So therefore, you are not living together. You have stated in one paragraph that he is coming Every weekend.
Every weekend,
But
Lordship.
nobody corroborates that from your matrimonial home also. From your matrimonial home also. Sorry, we
Lordship, I have lost my son.
fully sympathize by that.
And for the fault of the learned advocate who conducted the.
No, this is not anybody's fault. You had your occasion to.
They should have brought some.
We are sure that if a witness is brought, any advocate, the other evidence is quite all right. So if there was an evidence, we are sure that the advocate must have asked your client whether there is any witness regarding this. Anybody from the workplace, or regarding this, he's coming every weekend. Anybody from even your domestic help who works under you would do. You could not bring them also. Your advocate must have asked your client, bring a witness. If your client does not bring a witness, what can the advocate do?
And Lordship, the respondent is not very.
We can think about, you file at section 26. You file a section 26, we will grant alimony, permanent alimony, whatever is due to you.
Yeah,
You can file even after we pass a decree about divorce. That can be filed anytime when marriage is severed. Do that, we will grant, and we have determination till now. So file a section 26. Who prevents you from doing that? But this marriage cannot survive. 9 years after the judicial separation decree.
Lordship, why he came after 9 years?
There is a limitation.
Kindly, sir. Lordship.
We'll record that submission of yours also. The present appeal has been preferred by the plaintiff husband against the judgment and decree of the learned trial judge, whereby the husband's divorce suit on the ground of cruelty and desertion was dismissed. Next para, learned counsel for the appellant submits that the wife leveled serious allegation of illicit relationship of the husband with another lady. In her evidence, she failed to corroborate the same by way of any other witness than herself. Secondly, it is submitted that the husband had obtained a decree of judicial separation as long back as on November 21, 2006. The present suit for divorce was filed in 2015. During these long years, cohabitation between the parties never resumed. It is submitted that the husband has been attempting to bring back the wife to reside with him, but without any result. Learned counsel points out to the pleadings and the evidence of the husband adduced in the suit and contends that the husband has been residing in several places, first in a rented accommodation in Kharagpur, thereafter at Bhawanipur, and then at Malancho. However, since the husband was not permitted to enter into the Malancho rented accommodation, he again went back to his workplace Kharagpur, and he again went back. He shifted to another rented accommodation at Kharagpur, which is also his workplace. Next para, learned counsel submits, by placing reliance on the judgment of Shamar Ghosh versus Joya Ghosh, reported at 2007 4 SCC 511, that if the matrimonial tie between the parties has broken beyond repair, the marriage should be dissolved. Learned counsel for the appellant also cites Sukhendu Das versus Rita Mukherjee, reported at 2017 9 SCC 632, for the proposition that in case of irretrievable breakdown of a marriage, where the marriage is totally unworkable and emotionally dead, and beyond salvage, the same should be dissolved by a decree of divorce. Next para, learned counsel also places reliance on the evidence of the husband and submits that the plaintiff case has been sufficiently corroborated thereby. The evidence of OPW2, the father of the respondent wife, was hearsay evidence, it is argued. Next para, learned counsel appearing for the respondent wife contends that it is without explanation as to what prevented the husband from filing the divorce suit for a long period of 9 years between November 21, 2006, when the decree for judicial separation was passed, and till the divorce suit was filed. Full stop. It is submitted that the wife categorically stated in her evidence that the husband used to come every weekend to the matrimonial home, where the respondent wife has been residing all along, and used to live with the respondent as husband and wife. Full stop. It is further argued that the OPW2, the father of the respondent wife, also supported her evidence by leading independent oral evidence. Full stop. Next para. Insofar as the allegation of illicit relationship is concerned, learned counsel submits that it is difficult to produce witnesses to prove such relationship. Full stop. Next para. It is further contended by learned counsel for the respondent wife that the very fact that the husband waited so long to file the divorce suit, as well as that the wife has been residing in the matrimonial home all along, go on to show that the that the conjugal relationship between the parties was never severed. Full stop. Next para. The court gave notice to both parties that it might be relying on the judgment of Rakesh Raman versus Kavita, reported at 2023 SCC Online SC 497 in the context of the present suit. Full stop. Next para. Learned counsel for the husband submits that the said judgment inures in favor of the proposition sought to be advanced by the husband. Full stop. Next para. Learned counsel for the respondent wife submits that in the said reported judgment, the marriage between the parties the conjugal life between the parties was broken for a long period of 25 years, and there was no child no issue of the marriage. Full stop. It is submitted that in the reported judgment, the relationship between the parties had ended. Full stop. Next para. However, the facts of the said case, it is submitted, are different from the present. Full stop. Next para. It is reiterated that since the wife has been residing in a matrimonial home, the ratio laid down in Rakesh Raman's case is not applicable here. Full stop. Next para. After a careful perusal of the impugned judgment and hearing learned counsel for the parties, we find certain cardinal features in the matter. Full stop. Next para. First, in the written statement of the wife, she leveled serious allegations as to alleged illicit relationship of the appellant husband with a lady who was working in the diesel POH shop at Kharagpur railway station and worked as khalashi. Full stop. Next para. Such specific allegation was reiterated. Please take your seat. It was reiterated in the evidence of the wife as well. Full stop. However, despite such specific details being furnished about the alleged illicit relation, it is surprising that the wife failed to produce even a single witness from the said locality and or from the neighborhood, where the alleged illicit relationship fructified, in order to corroborate such serious allegation against the appellant husband. Full stop. Next para. The OPW2, being the father of the wife, is obviously an interested witness. Full stop. Even if we proceed on the premise that the OPW2 was not leaning or biased in favor of his daughter, paragraph number 8 of the examination in chief of the OPW2 categorically mentions that his daughter, within bracket, the present respondent hyphen wife, bracket closed, came to know that there was an illicit relation between the appellant husband and the said lady. Full stop. Next para. It has also been repeated that Gradually, the appellant used to stay with the said lady at her quarter. Full stop. Next para. Apart from the nature of the allegation indicating that the said evidence was hearsay insofar as the purported illicit relationship is concerned, comma, in the event the the respondent and her father were so sure that the appellant used to stay with the lady in an amorous affair in the quarter of the said lady, comma, it defies logic as to why not a single soul, SOUL, was brought as witness from the said neighborhood to corroborate such serious allegations. Full stop. In the absence of any concrete proof of the grave allegation of illicit relationship, comma, the said allegation itself takes the shape of cruelty. Full stop. Next para. That apart, comma, the husband, comma, both in his pleadings and in his evidence, comma, reiterated that he has been living outside his parental home during the entire relevant period. Full stop. Next para. Although the respondent wife has been residing in her matrimonial home, meaning thereby the parental house of the husband, comma, since the appellant husband himself did not reside there, comma, mere living in the matrimonial home could not could not signify automatically that the respondent wife was living with her husband in conjugal relationship there. Full stop. Next para. Rather, comma, the respondent wife states in her evidence that the husband used to come every weekend and take the son of the parties to the doctor. Full stop. Next para. However, comma, if the respondent wife has actually been residing in the matrimonial home all along, comma, it is also unexplained as to why not a single witness, comma, not even a domestic help or a neighbor or any member of her matrimonial family could be brought as witness to corroborate the fact that the husband used to live with the respondent wife in conjugal relationship during the relevant period. Full stop. In the absence of any such witness, comma, we cannot but draw adverse inference in that regard against the contention of the wife regarding the husband having lived in conjugal relation with the wife. Full stop. Thus, comma, seen in proper perspective, comma, the after the decree of judicial separation passed on November 21, 2006, comma, we do not find any concrete evidence on record or independent corroborative evidence to prove that the respondent wife ever made any effort to come and reside with her husband, comma, wherever he was living, comma, in a rented accommodation or not, and stroke or that the spouses lived together at any point of time after the said judicial separation decree as husband and wife. Full stop. Next para. Although the appellant husband has relied on Sukhendu Das's case, comma, we are unable to accept the said decision as a binding precedent since the said judgment was rendered under the powers enjoyed by the Supreme Court under Article 142 of the Constitution of India, which benefit the High Courts do not have. Full stop. It is well settled that judgments passed by the Supreme Court have binding effect under Article 141 of the Constitution of India if the law of the land is laid down therein. Full stop. Article 142, comma, as opposed thereto, comma, deals with the special powers of the Supreme Court to do complete justice between the parties. Full stop. Next para. Thus, comma, the ratio laid down in Sukhendu Das cannot be taken to be a binding precedent in the present context. Full stop. However, comma, in Shamor Ghosh Supra, comma, the Supreme Court, comma, in paragraph number 101 within bracket Roman XIV bracket closed held that mental cruelty includes a situation where there has been a long period of continuous separation, comma, and it may be fairly concluded that the matrimonial bond is beyond repair. Full stop. The marriage in such case becomes a fiction, comma, though supported by a legal tie. Full stop. By refusing to sever that tie, comma, the law in such cases, comma, it was held, comma, does not serve the sanctity of marriage, semicolon. On the contrary, comma, it shows scant regard for the feelings and emotions of the parties. Full stop. In such like situations, comma, the Supreme Court held, comma, it may lead to mental cruelty by itself. Full stop. Also, comma, in Rakesh Raman Supra, comma, which we have referred to above, comma, the Supreme Court categorically observed that it is not possible in every case to pinpoint to an act of double inverted cruelty or blameworthy conduct of the spouse. Full stop. The nature of relationship, comma, the general behavior of the parties towards each other, or long separation between the two are relevant factors which a court must take into consideration. Full stop. The court, comma, while holding so, comma, also took into consideration the ratio laid down in Samar Ghosh Supra. Full stop. Next para. Upon a detailed consideration of the context of mental cruelty, comma, it was held by the Supreme Court that in a given case, such as the one at hand before the court in that case, comma, where the marital relationship had broken down irretrievably, comma, with multiple court cases and long separation and absence of cohabitation between the parties, comma, then continuance of such a marriage would only mean giving sanction to cruelty which each is inflicting on the other. Full stop. The Supreme Court observed also that a dissolution of the said marriage would affect only the two parties as there was no child from the wedlock. Full stop. In the present case, comma, most unfortunately, comma, the child of the parties has met his demise since. Full stop. Next para, that apart, comma, we find that the interesting ratio laid down for the first time in Rakesh Raman Supra finds its ECHO in the present case. Full stop. Next para, for the first time in Rakesh Raman Supra, comma, in continuance of the CUE left in Samar Ghosh Supra, comma, the Supreme Court categorically brought irretrievable breakdown of marriage between the parties within the conspectus of the concept of cruelty, comma, which is a ground of divorce under the Indian marriage laws. Full stop. Next para. The Supreme Court, comma, in Rakesh Raman Supra, comma, held that if the marriage is irretrievably broken down between the parties and there is no consummation, no conjugal life between the parties worth the name, comma, it tantamounts to cruelty by the spouses against each other, and if such a marriage tie is not severed, comma, it would tantamount to more cruelty between the parties. Full stop. Next para. In the present case as well, comma, in view of our assessment of the evidence as above, comma, we find that the marriage has irretrievably broken down between the parties. Full stop. Moreover, comma, since over a long period of 9 years after the decree of judicial separation was passed in November 21, 2006, comma, it itself affords a ground for divorce to the appellant husband. Full stop. Next para. In such view of the matter, comma, we are of the opinion that the learned trial judge failed to take into consideration and advert to the components discussed above and erroneously refused to grant a decree of divorce. Full stop. Accordingly, FA 112 of 2021 is allowed on contest, comma, thereby setting aside the impugned judgment and decree dated February 26, 2021, passed by the learned additional district judge in charge in the court of additional district judge within bracket re-designated court, comma, Poschim Medinipur in matrimonial suit number 731 of 2015 within bracket CIS Matrimonial suit number 569 of 2015, bracket closed. Full stop, we hereby grant a decree of divorce in favor of the plaintiff appellant against the respondent wife. Full stop, next para. However, comma, there will be no orders to cost. However, comma, we make it clear that nothing in this, nothing in the above observations shall prevent the appellant, respondent wife from taking out an appropriate application for permanent alimony under section 26 of the this is a Hindu Marriage Act.
Lordship can grant permanent alimony in this.
Without any evidence, we cannot.
What is
You have to show the asset. Huh?
Can two?
What is can two?
I don't know where.
Can two is nothing, can two dispose.
No. There is no kind.
Section 26 of the Hindu Marriage Act for permanent alimony, full stop, if such an application is filed, comma, the same shall be dealt with independently on its own merits. Full stop, can 2 of 2024 is treated to be on the days list. And in view of the above disposal of the appeal, comma, above disposal of the appeal, comma, is also deemed to stand disposed of. আচ্ছা এই ফর্মাল ডিগ্রি বি ডন আপ অ্যাকর্ডিং টু না ওই কস্টের পরে লিখে দেবো না তার ইয়ের পরে সেকশন 26 এর যেটা বললাম তারপর ক্যান টু তো রেকর্ড এখানে নেই তো ফাইলে নিয়ে ট্রিট করে ওটা ডিসপোজ you have to file an affidavit of asset and all those things in a section 26 file it will grant it thank you এটা ঢুকে যাবে
My lord, should have filed before my lord.
no we have determination, that's why whoever has determination file there. Section 26 you can file now. After the decree is dissolved, you can file it in any point of time. File it quickly. Mr. I will help you. Give a copy to them before. Next.
Item number 31.
Yes.
Although I am appearing on behalf of the respondent number 1 and 2, defendant number 1 and 2.
But you are asking for time for
No. Mr. Mahato was here. My lord, he requested me to place the judgment so that the matter is not adjourned. My lord, he is coming. He is.
What is the matter about Mr.
In a partition suit, my lord, in the preliminary degree, my lord, the share has been declared. The only flaw I could, my lord.
What is his case and what is your case? We'll decide that.
My lord,
you may win also if you are very convincing on his case.
No, my lord, according to me, the learned trial judge has taken all sorts of pain to declare the.
Mr. Rai, what is Mr. Mahato's best case?
Best case is this, my lord, that he wants that the property which was, my lord, devolved upon me in respect of B, D, and F schedule. He wants that this should be also they have the share in respect of that property, although exclusively those property is of mine.
What is the basis of his case?
My lord, according to my lord, me in the judgment, my lord, it has been elaborately discussed.
So according to him, what will be there?
My lord, suit, my lord, kindly see, my lord, the.
Because here, Mr. Rai, you know, in our court, it's very difficult to start the judgment, and you know very well. You and Mr. Mahato, both of you know. So you have to ask the points to Mr. Mahato. If he,
I think what he will say,
yes,
that is at page 154, the concluding part of the judgment. The learned judge ought to have declared the share and said the suit is decreed in preliminary form, declaring this share. Here, the learned judge, what he has said, that the suit B and the same is dismissed on contest with cost. So, the
whose suit? His suit.
His suit.
His suit. That's it.
His suit.
He had to prefer an appeal then.
No, he has.
If you agree, we'll pass up because if you agree to the shares, otherwise.
I agree to the shares, but what Mr. Mahato will say. Yes, now, only things, I think this should not have been.
Why should it? Why was it dismissed? Mistake.
It's by mistake.
Copy paste.
It's by mistake. It should have been declared in preliminary form. Although in the judgment it has been elaborately discussed which properties belongs to
share
who.
And all.
Share, everything has been discussed.
Either we we can
modify
modify it, and the shares, where are the shares declared?
Shares has been declared at page, my lord.
Or Mr. Rai, we can just remand it for the limited, just to dispose of within a month by passing a proper, set aside this, remand it, and on the basis of the findings which are already on record, to pass a preliminary decree declaring the shares of the parties within a month.
My lord,
See, Mr. Mahato agrees to have a talk with him, we'll do that. We are passing it over.
my lord. Today is at 3:30. I do not know, my lord, whether he will be coming before 3:30 or not, my lord.
You are making it not today then.
My lord, kindly.
We'll give him a last chance because you have, because of your fairness, we'll give him a last chance. He should have been here by now. His junior is also there. He's very active. He remains in court.
Junior has not come today, my lord. I am told.
None appears for the appellants at the time of call. Full stop. Although we commenced hearing the learned senior advocate appearing for the respondents, comma, since the appellants are absent, comma, we cannot proceed with such hearing today. Accordingly, let the matter stand adjourned for the day. This should help him. He has come. Yes, Mr. Mahato, please come here. Suit was wrongly dismissed. Shares have been held. If you agree to the shares, we'll remand and direct the trial court. We'll set aside the decree, remand, direct the trial court to pass a preliminary decree in terms of its findings regarding the shares of the parties. If otherwise you are agreeable to the shares.
Well, some properties, it has been declared that I have no share.
Acha, what is the basis of that? So then you have to challenge that also. So what is the ground for challenge? Oh, we are to get exchange of transfer. Yes, Mr. Mathur. What is the logic of the court in not granting, giving those shares to you?
All the parties, necessary parties have not met.
No, those some portions were exclusively given to Mr. Rai's client, probably. So that those portions could not be given to you.
So far as D1 and D1, the gift deeds, which I have challenged.
You have challenged gift deed also?
Yes.
What is the ground of challenge?
My lord, it has been obtained by practicing fraud.
You could not prove, so court did not grant. Fraud is very serious. How did you prove fraud?
The property was owned by the husband of the appellant, the present appellant.
Yes.
My lord, it has been produced that my husband has gifted the property in favor of the respondent, number one.
Who are they? How are they related? Your husband and the brothers. So chose the brothers instead of the wife. What can be done? So that is a choice many people may make.
On that issue, my lord, the appeal is required to.
But fraud you have to prove.
I have to prove.
What proof did you adduce?
My lord, first thing is, my lord, although they have produced the deed long back, but they have taken mutation after a long time.
So, Mahatma, that
after getting
mutation does not retrospectively vitiate the deed.
It is a fraud because, my lord, they have not taken immediate step, and immediately after getting the notice of that mutation proceeding, my lord, I have challenged, filed this.
Just because you have challenged does not make it a fraudulent transaction. Gift deed was executed, registered must be registered. Yes. Both of them signed, accepted, 122, 123 satisfied.
The evidences are required to be taken, looked into, my lord.
What evidence? Show us one evidence of fraud.
So far my pleading is concerned.
Yes. No, not your pleading. Show us the evidence. Apart from your your deposition that it's fraudulent. You must have deposited it is a fraudulent document.
There is nothing apart from my evidence. There is.
Then, Mr. Pramath, fraud not proved. So those exclusive portions go to them.
Well, that, my lord, kindly see these findings of the learned judge and the, my lord, the evidence.
What's your best evidence? We are looking at that. We are wanting you to produce your best evidence regarding fraud.
What is my pleading?
Mr. Mahato, forget the classical thing. You have to show the evidence.
I have not read the entire.
Acha, very well. You know, not. Show us the pleading. Mr. Rai, take your seat.
Page 3, paragraph 3.
Yes, page 3, paragraph 3.
Property described in Schedule B below is the property of the Mola.
Yes.
Before doing MSc in geology, the defendant number 1
was serving in a school as an assistant teacher. After taking MSc degree, he became the lecturer of Jangipur College. Rampada Pahari was also sufficiently educated. He was a teacher in school of Kirgola. The plaintiffs are the heirs of Rampada Pahari. Ramapada Pahari suffered from cancer. He suffered as such for a pretty long time and was treated by the doctors in Calcutta as well as Vellore Christian Association. The defendant number one, very intelligent, and he had sufficient over the property matters, and during the lifetime of the father Samapodo and during the ailment of Ramapodo, as well as after the death of Samapodo, Umapodo looked after the properties of Samapodo, Ramapodo, and the others of the joint family. Ramapodo respected the regarded his elder brother Umapodo and the defendant number one very much. He used to obey the defendant number one very much. Defendant number 6, Vishnupodo, also held much respect and regard to the defendant number one. The plaintiffs also respected and regarded the defendant number one. The plaintiff, including Ramapodo, always used to obey the defendant number one as well as defendant number 2, Ramapodo, was very simple person and was a man of cool temperament. He used to believe the defendant number one being his elder brother and the defendant number 2 being the wife of the elder brother. The plaintiff do not possess and knowledge about the properties and its proper management. Ramapodo died of the attack of cancer, leaving the plaintiffs in a very wretched condition. The plaintiffs became helpless and almost destitute. On the death of Avinash and Vimola, the share of Avinash in B-schedule property was inherited by the children of Samapodo, that is the defendant number 1, Umapodo, and Ramapodo, since the deceased of the defendant number 6, Vishnupodo, and the defendant number 3, 4, and 5 being 3 daughters of Samapodo, and accordingly each of the aforesaid persons inherited the property so left by Bimola. Accordingly, the plaintiff have inherited 1/6 share in B-schedule property, and they are in possession of the same. A few months back, the plaintiff number 1 received a notice from the office of the BLLR Daton 2 in respect of the mutation in respect of the properties in plot number 191, 192 of Sutmaja.
Mr. Mahato, you have made out a case of impersonation in the registry office and signatures not telling in clause D that the fifth pages 1 to 5 and the reverse signatures do not tally, and that the signatures made in the registry office was different. Did you ask for any expert?
Well, my lord is already of the opinion that so far the shares which has been held by the
We have not found any opinion. If you are of that, I mean, otherwise there is no difficulty in the.
is remanded back along with these two properties, my lord.
Yes.
With these properties, that whether they gift it or obtained by fraud and.
No, but you failed to produce prove that. Why should you reopen that? If you remand, you will remand only setting aside the dismissal and directing the court to pass a preliminary degree on its finding, on the findings which are already there,
What I am submitting, my
including the gift deed finding.
These two deeds.
No.
He is required to be remanded back, my lord.
You failed to prove utterly. No expert witness was sought. Why should you reopen that? Your laches cannot be fulfilled by the appellate court. You cannot fill up your lacunae.
But from the
No expert, Mr. Mathur. There was no proof of the fraud. Just your allegation. It was a bolt from the blue from you, for you, that you have stated. But if you don't take out, adverse inference will be drawn against you. If you don't seek a handwriting expert.
handwriting expert, I have not.
You have not sought, obviously. That was the only ground, actually. Two grounds, impersonation, related grounds. Signature of a different person, therefore impersonation. You don't prove the signatures. It's your onus, not proved. So then it remains. Whatever are the findings.
The main issue, my lord, in this appeal. These two gift deeds.
Apart from that, the suit has been dismissed.
Yes.
Regarding the other person.
With liberty to file a phrase. That liberty has been given.
Oh, liberty has been.
Yes. Therefore, only issue.
Unnecessary. Yes. This court decides after that what liberty remains.
Kindly see the ordering portion.
That is quite peculiar.
155.
155, yes.
Therefore, the plaintiffs or any party who are the co-signers in a suit party in plot number such and such may bring a fresh suit for partition, impleading the co-signer in dismissal of this. Page 154. Issue number 6, last 3-4 lines.
Yes, therefore, yes. All co-sharers means who are left out? Because you are not a co-sharer in those gifted properties, that's why.
That's one. Another matter, some property has been transferred to third parties. Those are required to be brought on record.
That has been held by the trial court.
Yes.
So they are to be added then.
They have to be added.
Yes, what about that?
To that, that is admitted that some of the property was jointly sold by the both the plaintiff and the defendant to third parties.
But those third parties, they are necessary parties.
Yes.
But their properties is not included in this in the
transfer properties
transfer property. But share has not been declared in respect of that in between Mr. Mahato's client and my client.
That cannot be. All the co-sharers have to be joined.
Between
two of the co-sharers, you cannot.
But
all the joint properties have to be brought in the hotspot.
Yes,
and
yes.
all the co-sharers
So,
also.
if it is, if your lordships remanded this matter, for a decision, let my property that has been declared in my favor, may not be reopened for a decision again. Let the properties they have purchased that may be considered by the learned trial judge again. Because they are the purchaser, they are the now their share has to be declared.
Mr. Rai, the difficulty is that we cannot segregate like that. Once we.
But in respect of the property which was sold, that is not in this schedule.
Yes.
In this
there.
not in
Yes,
B.
the written statement.
Not in the B, D and F schedule.
No, it cannot be piecemeal. Both of you, all the co-sharers sold those properties to third parties.
Yes.
Yes.
Demarcated portions.
Not demarcated portion.
Then,
not
if it was demarcated portion, all of you sold, then it would be a good sale. Demarcated portions sold, those portions could be deleted from the suit also. But if you sold undemarcated portions, they have a right over every inch of these properties also.
Apart
from those gifted properties.
This was sold. The properties are sold by registered deed. There is specifically demarcated portion that has been mentioned in those.
That does not pass. Title does not pass.
No.
The demarcated portions were shown in those.
Yes, specifically portion mentioned.
Then why do you say not demarcated?
Not demarcated means, so far as my portion is concerned, with that it has their portion has not been demarcated.
No. Suppose this is the entire property. If
Yes.
all the co-sharers demarcate a portion and sell it to somebody else,
Yes.
then it's like the original owner selling it out. If
Yes.
all co-owners together sold that property, a demarcated portion, that has to be deleted from the hotspot of the suit.
From the hotspot, yes.
Because that is for all practical. All of you agreed to demarcated portion being sold.
Yes.
All of you had right. You asserted the right and sold a demarcated portion.
Yes.
That portion simply should go out of the hotspot of the suit and they need not be added.
Yes, yes.
Mr. Mahato, if all of you, all the co-sharers sold together demarcated portions.
No, not all together, by different deeds.
Oh.
Obviously by different, not at.
Co-sharers join together and execute one deed, not that. By different deeds, transfer their respective share.
If your lordships kindly come to if your lordships kindly come to page 154.
In that event, opportunity has been yes. You have been given. They have been given opportunity to file a fresh suit. Does that affect you because the gifted portion will operate as res judicata?
Kindly see the page 154. First,
For B1 gift deeds, my lord, I can, my lord,
Waive.
But so for D1, my lord, it should be, my lord.
But that is a better property.
No, no, no. My lord, this is the property executed by my husband.
True, but your
But my lord,
husband
with
is
regard to that, no evidence.
What has to be proved, Mr. Mahato. You know that better than me.
My lord, page 154, my lord, first paragraph, last 4 line.
Yes, we have marked that only.
Therefore, the plaintiffs.
That is the only portion in the entire judgment you have marked.
My lord, that is my lord, the A schedule property.
All right. Acha.
Page 13, it is A schedule property. My lord, which they have the right.
My lord, may I submit one thing? My lord? Kindly give me, my lord, next week time. I shall talk with my client whether he will.
You agree to what?
My lord, whether the gift deed may be.
No, we'll make it an order of the court.
Yes, yes. Kindly.
No question of your client's consent.
No, my lord. Whether. No, certainly, my lord will not depend on
That portion, Mr. Mahato, is final. In full and final settlement of your claims. That portion we won't reopen. Either we don't interfere with this, retain whatever is there, you are entitled to file a fresh partition suit. In that event, that finding regarding those portions will operate as res judicata against you.
regarding the gift deeds.
Regarding the gift deeds. Or otherwise, we can direct it to, then that will be a new exercise. We'll have to direct them to be implemented. They'll come in and. Peculiar situation is nobody has opposed the demarcated sales of the property.
This is plaintiff's portion. So far as the suit plot number 81, 87 and 90 may bring a free suit for partition impeding all co-sharers in spite of dismissal of the suit. This is a plaintiff's portion, a schedule property that has been mentioned in page 13.
In the plaint itself, that has been mentioned to be the plaintiff's property.
Kindly see.
Page 130, court has declared that I am the co-sharer in respect of plot number 81, 9.
A schedule property, plaintiffs are co-sharer in plot number 81 and 90. Plaintiffs, there the court declares plaintiffs got number 1 got 135 share, plaintiff numbers 2 to 4 got 415 share each. We have no share there in a schedule property. We do not have any share in the A schedule property and we do not have any share in respect of E schedule property.
The suit itself was bad. How could you join properties? How could they join properties which was not in respect of which all of you are not co-sharers? If A was his exclusive property or
no, it has been, it is in their position, it is admitted in the plaint also that A schedule property is his property, and in so far as because all the properties have to be bring in the hotspot, so A schedule, A to E schedule, I schedule property that
it was a joint property all the same.
So far as A schedule and E schedule.
Plaintiff declaration plaintiff has 1/6 share in A schedule property. 1/6 share in C schedule property.
They're not claiming exclusive.
No.
We have the court declares that in so far as that A schedule property, I do not have any share. In my
how can you not have any share? How can you not have any share? It was never demarcated.
Because this is with regard to the A schedule property. Kindly come to kindly come to kindly come. May I have prepared a chart.
Prayer A of the plaint. I have stated that they have also the defendant number 1 has also 1/6.
1/6. What was the basis of the court holding this? Plaintiffs or any of the parties? Facts did not. I would like to conclude.
I have
only 81, 87 and 90 has been sold to different parties.
Yes.
That's why.
How this property?
No, court is correct. Court is correct. Those properties remain joint because even if you sell, one of the co-sharers sell a demarcated portion, but the effect will be that his share is only sold.
Yes. Now, the court has
court has said the plaintiffs or any of the parties who are co-sharers in respect of those plots,
yes,
including those third parties also,
yes,
they may also prefer a partition suit. So all of you can prefer a partition suit, but the partition suit, no, the suit will not be in respect of only those. That is where we are making a mistake.
But my lord,
Suit
their
will be for the entire
share to
property.
be declared in respect of
Not also
that
that.
plot.
Court says because the co-share, some of the co-sharers in plot 81, 87 and 90, they have not been implemented.
Yes.
Therefore, court says the new suit will be for the entire property. Court says therefore the plaintiffs or any of the parties who are co-sharers in respect of suit plot numbers such and such, may being a fresh suit for partition impeding all co-sharers in respect of dismissal, in spite of
But
dismissal.
my
That
lord,
suit will be for the entire property.
suit
But
will
by
be- suit will be for the properties, my lord, in respect of suit plot number 81, 87
no, not
and
that,
90.
not that. Suit in respect of the entire.
Yes, yes. No, no, no.
plaintiff-
Yeah,
We are
all
telling
the
you-
parties should be, my lord, bring into the
Hotspot of the
plane, hotspot of the
plane.
plane, and they should be made parties. But my lord, the partition will be in respect of these 81, 87 and 90.
Not that. Therefore, the plaintiffs or any of the parties who are co-sharers in respect. So, therefore, plaintiffs or any of the parties who are co-sharers in respect of suit plot numbers such and such.
These three plots. In respect of these three plots.
Apart from these three plots, the other regarding the other plots, the court has declared the shares.
Yes, yes.
Where is
Yes.
that declaration?
Yes.
Page 151. Yes, 151 is a summary. I summarize my findings.
My lord, the court has, my lord, declared.
Page
each and-
151 is the second paragraph is that is the crux of the judgment. I therefore summarize my findings. Page 151, second paragraph.
Yes.
So they have been found to be absolute owners in respect of E. So
Yes.
E goes to them.
E goes to them.
B, D, this F, G, H and I, they have no right, title and interest because of your gift deeds.
Yes, yes.
So whatever remains is these should go out.
B, D and F exclusive of my clients.
B, D, F, G, H and I.
G, H and I are the gardens and the ponds.
Those are common.
G, H and I.
That has not been held also.
Yes, yes.
On the other hand, the plaintiffs are found co-owners in respect of undivided plot 81 such and such. এইভাবে
G, H and I, they could not, my lord, establish their title.
whose title that is not said.
Yes, yes. Title of plaintiff.
Plaintiff have not proved title regarding BDF, G, H and I.
Yes.
But it has neither been declared that you are the owner of the property.
My lord, you know,
Previous findings will show
previous
that.
findings, my lord. Thus, the top of that, accordingly, I hold, my lord, 151 top. Accordingly, I hold that plaintiffs have been unsuccessful in establishing their ownership in respect of H and I scheduled properties. Now, my lord,
What about G?
G, my lord, kindly,
F, G.
my lord, E, G schedule, my lord, kindly come to page 149.
Each property has been dealt with separately.
Separately, my lord, the court dealt with every property separately, every schedule separately. Now, my lord, kindly see how the devolution that has been made in respect of G schedule properties, that is there. May I read for you, Lordship? The defendants 1 and 2 have admitted in their written statement that late Shamapada Pahari gifted such property to late Rampada Pahari by registered deed number.
No, the effect is that Mr. Rai, they have failed to prove that it is their exclusive property.
Yes.
So what is the effect? It's a joint property then.
No, no, no.
It's nobody's property. None of the property's property.
No, no, no. It's mine. It's mine.
That has not been held. Rampada Lahiri was a common ancestor.
My lord,
Not your ancestor, Rampada Lahiri.
Rampada, my lord, Rampada and is the
Shamapada and Rampada.
Shamapada and
Those.
Avinash. Those who are they are
is
the
the original
Akha is the
owner?
original owner.
Yes.
Then my lord, from Akha, Shamapada and Avinash. My lord, Avinash has married. My lord, he died issueless in
You
Bimala
claim through
was his
Avinash.
wife. My lord.
You claim through Avinash.
No, no,
My
no.
lord, no,
From
no.
Shamapada.
From
We are from
Shamapada.
all are from
Oh, the way of Shamapada.
Shamapada, my lord, there was exchange of
Shamapada
properties
gifted the
between,
property to Rampada.
yes, my lord, Shamapada and my lord Abhinash, there was exchange in respect of some of the property. That is also, my lord, a exhibited document. I got the property from Shamapada and my lord from Bimala by
G schedule Shamapada gifted to Rampada.
Yes.
Ramapada.
Yes.
So Ramapada, you are not claiming from Ramapada.
No. Ramapada is, my lord,
Who is
Mr.
Tapon Acharya and others? They are third parties.
They are the third parties.
Therefore, G was transferred by Ramapada. The court holds Shamapada, your common predecessor, gifted property to Ramapada, and Ramapada transferred during his lifetime to Tapon Acharya and others. So therefore, not you, neither yours, not theirs. Third party, Tapon Acharya, not you.
G and
G,
only G.
So therefore, not your property.
No, G is not mine. I am the
You are
owner.
saying that
in
G
respect-
is
no, I'm sorry, my lord. I am
It's not your
B,
property.
B, D, and F.
But then if all the co-sharers are not parties, Mr. Rai, then all of the co-sharers have to be included.
But my lord, it should not be, my lord, reopen, my lord, de novo trial should not be there because, my lord, it has already been declared. So far as, my lord, the transfer is share is concerned, for that it can be, my lord, sent down on.
Let us say this. Let us take this. Shamapada, could he sell a demarcated portion to gift a demarcated portion to Rampada? He gave his share to Rampada. He could give his share only to Rampada because all of them are co-sharers. There was no partition previously. That's why these partitions were. So Shamapada, your common predecessor, gifted his share to Ramapada. Ramapada sold that property to the third party. Now, therefore, what was sold by Ramapada was ultimately Shamapada's share.
Yes.
Shamapada's share in G.
Yes.
But then, if that be so, there was never any demarcation. It was not a demarcated transfer. Whoever purchased claims through Ramapada whatever Shamapada had. So Shamapada was originally a co-owner.
But my lord, the portion that has been transferred, that is there.
Not exclusively Shamapada's. That
Well,
portion in the first place,
the portion of
it started with the gift
portion
deed of
which was
Shamapada.
transferred, the portion which was transferred,
Was
that is
Shamapada's
admitted.
share. Maybe. But that was at best Shamapada's share. He could not transfer any demarcated portion. Shamapada, your common predecessor, started the problem actually.
Yes.
The gift deed demarcated portion was gifted to Ramapada. Ramapada gave to Tapanacharya. Shamapada could not gift a demarcated portion to Ramapada. Because apart from Shamapada and Ramapada, there were other co-sharers also. Or only these two?
No. Shamapada.
Akkoy had other co-sharers.
Shamapada, Ramapada. They are
Six.
Then on the death of Shamapada, there are 6.
Oh, then he could not give.
2 sons, 4 daughters.
No, they are all Shamapada's heirs.
Yes.
No, Shamapada had any other co-sharer apart from Ramapada?
Yes,
Abhinash was there.
No, Abhinash was there. Abhinash was married to Bimala. Now, like they were issueless. Now, Bimala transferred the property to to the defendant.
Bimala was the sole owner.
Sole owner in respect of Abhinash's share is concerned.
So therefore, share. Half share. So everything is a share. At no point of time, any person having exclusive title sold the property. Everybody transferred his or her share.
But when so far as the transfer is concerned, Mr. Mahato's client could not prove that all these transfers are vitiated by fraud.
Even if the transfers are not vitiated by fraud, those transfers were only in respect of the respective shares of these persons.
Yes.
So they could at best transfer their shares to you.
My lord.
In the entire property.
My lord.
So therefore, he loses his shares through Shamapada. That portion of the share.
Only, my lord, upon remand, if it is, my lord, if your lordship, my lord, wants remand to be made, my lord, only the portion they were occupying in terms of
Fraud, he has not been able to prove that. We don't think it should be reopened.
Only, my lord,
what will be the nature of the remand?
Only the portion.
Entire portion is undemarcated, Mr.
And that has to be
the entire suit property has to be opened.
In terms of the deed, my lord, it has to be ascertained only that which portion is in occupation of which parties and my lord, the partition has to be made.
A deed executed by Shamapada in favor of Ramapada is the exhibit 6. Second part, second paper book, it is there, it is undemarcated.
Has to be undemarcated. Even if he sold a demarcated portion, his share will only.
Because original was on.
Will retain the findings regarding the fraud.
But kindly take it up on next.
Acha, correct. Mr. Mahato, regarding fraud, we are not very convinced. We are telling you frankly. We are thinking about retaining those findings on fraud and remanding the matter, directing the trial court to give you opportunity to the opportunity to add whoever has been left out and pass the decree afresh. But those findings regarding fraud will say that those have attained final.
That will be passed on the next.
Yes, not today. No, we are giving you the contour so that you can take instruction also, or you can prepare your client. So, hard in part for further hearing on. We are keeping it on next Thursday on May 8, 2025. Part 37, 8th May. Next Thursday. দেখে দেখুন যদি কেউ করে করবো। অ্যাসাইনমেন্ট ছিল তাহলে এলো কি করে, এখানে ঢুকলো কোত্থেকে? দেখুন কি হবে তাহলে, কত নম্বর? 32টা কি, এটা কি হেডিং এ ছিল? এটা অ্যাসাইনমেন্ট ছিল, এলো কি করে?
মানে
এটা টু বি মেনশনড থাকার কথা। It was directed to appeal. Yes. Why was it mentioned?
My lord, I mentioned the matter. My lord,
You are also there.
No, my lord. Today we have to rise at 3:30.
3:30, Mr. Rai. We are what we do are if both sides agree.
We linger the proceedings for.
No, not at all. Continuing matters can be taken up, and we are honoring that fully. But if both sides agree, or only in those cases, or in
don't take me amiss, my lord. I am.
No, we are not. We know that.
my lord,
Yes.
I had mentioned the matter, my lord, for two reasons, my lord. First reason, my lord, your lordship, my lord, appeared for the plaintiff. I am for the plaintiff.
Oh, like
my lord.
My lord,
That is why, my lord, and
my lord,
the
I
second, my
from
lord,
the other side, I am
and
not
the
agreed, my lord.
second-
My lord, kindly
second-
reconsider, my lord. Kindly, my lord, take step.
and the second issue, my lord,
Kindly record my statement, my lord. We have no difficulty, my lord, here.
no, being an officer, my lord, it is my
it will be
duty to-
beyond your control when it. I mean, if some challenge is preferred.
and I have yes,
The days nowadays
Very well.
it's very difficult.
I obtain orders.
It will be entirely beyond your control.
Yes.
Your fairness does not necessarily translate to your clients or his next advocates. Nawal Sultan, I had appeared. You had briefed me.
Your lordship
Yes,
represented Hemant Kumar
Yes.
Chaudhary, my lord. Hemant
Yes,
Kumar.
somebody, yes, you had briefed me. Yeah. So, since one of us, within bracket Aman Nam, had appeared for one of the parties in the matter, let the matter go out of the list. Now, let the matter be released from our list on personal ground with liberty to the parties to take steps for assignment before a different division. Sorry.
Deeply obliged, my lord.
Sorry for having appeared for his client.
This was very much expected, my lord.
No, my lord, we wanted to do the matter, but
No, we know
this is
that.
the difficulty.
But these are, I mean, for our benefit, actually, you have
Yes,
said.
yes.
Great. Yes, Mr. Poddar. Unless both sides are present, Mr. Poddar, let us not pick up matters today because you have a resolution. You'll just pass it.
He was there since it is 3:30 only.
Who was there?
My lord, Mr. Roy.
Oh, Mr. Rai himself was there.
Yes. Initially, my lord. Till 3 he was there.
No, yes.
Thereafter his junior was there.
Very well said. Then let us make it not today, just it will retain its position in the list.
Then next Thursday, my lord.
No. It will remain in the list. It will remain in the list. If we can reach hearing matters any other day, we will reach it. Tomorrow we sit singly. Tomorrow there is no scope.
No business, I
So
know.
from here.
Lordship 34, I'm for the appellant. I'm led by Mr. Mukherjee. He was present over here.
Prowal Mukherjee?
No, Mr. Tanmay Mukherjee.
He won't be there. Any matter in which both parties are present or there is any urgency? তাহলে ডেকে নিন ইয়েদের শুধু শুধু কল করিয়েছি মানুষ একটা বড় অর্ডার হয়েছিল তাহলে টাইপ করতে পারবে তোমার একটা বড় অর্ডার পড়েছে আজকে তাহলে ওকে একটু রেখে দিই আমরা অন্য ডিকটেশন পুরো যাবি